I do. Yep, I explained it to Mr. Lonzo.
Okay.
Right, yeah.
Very good.
A lot morning, a lot morning. You guys get combat pay?
Thank you. Welcome to go get this passports off. If not, you don't have to give you, I'll tell you all that you do, I'll tell you everything.
Yeah?
Well, it's just like I have a question.
It is, and they're weird.
Is there such a
Boy,
thing
7
here?
of these.
Not at all.
Uh-huh, I
No?
didn't realize it was like.
Yeah.
I just saw the picket when, yeah. Yeah, but they're small. Listen, I can justify it. That's what Julie
What
said.
is that, Dave? It's like a different pay scale or something? Oh. I'll tell you, it's a different world. You know what I mean?
Wouldn't you?
So, you can't,
I
I
mean,
got to trust
I-
somebody that's to the food activity. You can't take that stuff like that.
It's my little copy.
You know, I was with the guy the other day, well, it's been a while. He's a little older guy,
Can't do that.
and we're behind this car, I'm in my turn lane. They don't move, and they lean on the horn.
So,
I said, hey, Richard, you can't do that.
you get like all different grinders, cause you couldn't
You
get
people get out and see,
in with the,
you know, even just tapping them.
Yeah.
It's just-
They get upset. You know?
But this guy, he's had a history. I got upset because Donna came to get me, but I was in a Teams meeting, so she didn't interrupt me. I said, you interrupt me.
Yeah, for something like that,
You
yeah.
interrupt me, I don't care what I'm doing.
no, that was, oh, this one was, no, that was actually. I'm pretty sure it's it. No. I think you, I think you. I think.
Yeah, we'll do that after the hearing. So here we have.
Okay.
I had posted for it.
Hmm?
I had posted for it just to
Okay.
self-development here right now.
Okay, cool. I know, Catherine, you too.
Yeah. So they're very adamant about it.
I mean, I guess it's smart. Do you have one? Just a few hairs.
I know.
Thank you. Morning.
Sorry, we're a few minutes late out of Orlando. Y'all ready?
Yes, sir.
All right. The time is 9:05. My name is Christian Waugh, and I hereby call this February 2025 Code Compliance Hearing to order. At these hearings, we follow an agenda. The first item on the agenda is the call to order. The second item on the agenda is the pledge to the flag, so I'd like to ask you to join me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay, the next item on the agenda is the minutes from the January hearing. I have reviewed the minutes. Does anyone else have any proposed modifications, changes, deletions, or so on? All right, hearing and seeing none, I'll go ahead and sign and approve the minutes.
Staff update, abated and continued cases are listed out front.
All right, so I want to read it's not a brief statement, but it's a statement. So, good morning, my name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by law, but what it means is that Citrus County has hired me to preside over this hearing. What I'm going to tell you during this opening statement applies to all of your hearings, so I'd appreciate it if you'd pay attention. When your case is called, please come forward. You will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call its case, and I will allow the county to present its case, which may include evidence. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and to make legal argument. It's important that you take your time during this process because it is likely going to be your only chance to make your case. I will also ask whether or not you are contesting the violation. If you're not arguing that a violation exists, I'll assume a factual basis and just proceed to ask you how much time you need to fix the violation or to work with the county. This will help save time for yourself and others, but you are by no means required to do so. If you oppose the case or simply want to be heard, you have that right. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as briefly as possible. Although persons may be upset or even passionate about what they have to say, witness testimony should remain civil, and you must not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must fix the violation by that date, or a fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on your property. The county has the right to foreclose on that lien or seek money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate these into all my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, the cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs as well as the cost of the lien imposed. I may also decide to continue your case if I find a need for further evidence or argument. You do have the right to appeal any order I make today. Thank you for your attention.
First case is on the agenda today. Michael R. Novich, case numbers 2024-2117 and 2024-2133, pages 21 and 22 of your agenda. Expert on the case, William LaFame.
Good morning.
Good morning.
I'm just gonna wait for Ms. Delaplante. Sir, can you please raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Your name, please, sir?
Michael Novich.
Thank you.
Good morning, Mr. Novich.
Good morning. Julie Wilkinson, Citrus County Co-Compliance Officer. This is for 2 cases. The first one is case number 2402117, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The second case is case number 2402133, protection and use of rights-of-way, Section 7320A of the Citrus County Land Development Code. The address is 66 South Columbus Street in Beverly Hills. The property owner is Michael R. Novich. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on December 13th.
Actually, can I just stop you?
Yes, sir.
So which case, are you going to present exhibits in one case or the other case, or are they for both?
Yeah, for both at the same time, if that's,
Well, what I'm asking is the exhibit A you're talking about for both or just on one of the cases?
they're the same.
They're the same.
The same dates for the inspections. So the photos were taken on the same dates in both cases,
Mm-hmm.
but just different photos for each case.
All right, I think, here's what I'm asking. Is your exhibit A in one case different than the exhibit A in the other case?
Yes, sir.
All right, that's what, just what I want to know.
Okay,
All right,
I
thanks.
understand. Okay.
Please proceed, sorry.
Exhibit A, photos taken during initial inspection on December 13th, 2024. Photos from a corrective action inspection on December 31st, 2024. And photos of my final inspection conducted on February 17th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Okay, so you've got exhibits A and B in each case. The photos are taken on the same date, so your exhibit A dates are the same, correct?
Yes, sir.
All right. So, Mr. Novich, here's how this normally goes, and this is useful for others to see. Normally, I ask for the county to show what they want to introduce as evidence to you first.
Okay.
And I'll give you a chance to review and let me know if you have any legal objections to them being evidence. In other words, if you have comment on them, we'll get to that. But what I need to really know is, do you have objections to them being evidence? Are they fraudulent? Are they not real? Are they AI generated? That kind of thing. Does that make sense?
I believe so. So, the photos are a matter of fact, so I'm not to dispute, photographic.
Well, you haven't seen them yet, so I mean, I want you to have an opportunity to
Fair,
look at
fair,
them.
yeah. So I don't know the exact process. I'd like, cross-examination, and I am going to have objections, so.
Okay. Ms. Wilkinson, would you mind sharing the photos or your exhibits? And Mr. Novich, if you could go through them, Deputy, I don't know if you want to handle it or who wants to do this, but I'd appreciate, just look through, let me know if you have objections to them.
Yeah, yeah.
Okay.
Thank
And while he's doing that, Mr. LaFlame, where are you from?
I'm with Technical Services Division of Public Works.
From the county?
Yes.
Okay,
Yes, sir.
thank you.
While I'm reviewing these, can I present my USB to save time? Or will we
Well,
get
it
to
won't
that?
save time. I'd love to save time. But that's your evidence, I think.
Yeah,
So
yeah.
what I want to do is deal with their potential evidence first, and then I'll give you an opportunity.
So I don't dispute these photos as being accurate or
Okay.
truthful.
Right, all right. And so that's Exhibit A. I'd still like to make sure you go through Exhibit B. Thank you. Ms. Harrison, have you seen these?
No, I was up to
Okay.
ask Deputy after the.
What is this?
I don't know. What are you looking at? What does it say on the top?
It's the notice of violation for section 2031A, but I'm not seeing it for the right-of-way.
Okay. I mean, so it appears that you have a notice of violation for one of the cases. If you have an objection, I mean, I know you probably want to talk about it.
Well, I didn't know if this was supposed to be like comprehensive of
Thank you.
all of my violations, or if we're kind of
We'll get to that. I mean,
piecemealing it.
I'll have questions about that, and
Okay.
if you want, you'll be able to ask questions about
Gotcha.
that.
Okay, yeah, I see it. So I'll just see my duplicates. So if I had a point of clarification, or I guess to just point something out, that wouldn't be to necessarily dispute the accuracy of the photo? The reason I say that is because there's photos of like other people's homes in here, so,
Okay, no, that's, I
But
mean,
yeah.
that'll be important to bring up.
for sure. And actually, I think these photos may have been with that, sorry. And yeah, this is accurate. So yes, I agree with that.
Okay, so you don't have any legal objections to either exhibits A or B in either case, but you do want to comment on them? Or ask questions about them?
I guess I'm not really understanding as far as the terminology of objection or what that's gonna entail or not entail.
So basically, I don't necessarily want to look at the photos unless I'm satisfied that they're fair and accurate depictions of something that's relevant for the cases. And I understand that there's probably going to be stuff in the photos that the county may think is relevant that you don't think is relevant, or that may not bear on the case at all from your perspective, or maybe other properties. I mean, that's happened before.
So I object to the ordinance, but I don't dispute that those photos are real
Okay.
and that the photographs are
That's what I'm kind of getting
objectively
at. That's what I'm
true.
getting at.
Yeah, yeah,
They,
okay.
they depict a slice of reality. All right,
Yep.
so I will admit exhibits A and B without objection. Thank you, but I'm not making a ruling right now.
Yeah.
I am curious, which ordinance are you going to be objecting to, or
Really, this is the focal point on this case is the right of way.
okay, so not so much. I'm not trying to prejudge anything, but
Yeah.
you're not challenging the constitutionality or the legality of the junk ordinance, so to speak. But are you going to be making argument about the right-of-way ordinance?
Well, I guess I'm seeking clarity more than anything. So even to the junk, I would be seeking additional clarification because at this point, what I've been told orally and verbally is now in question.
Okay.
So out of an abundance of caution, it's having to get quite fact-based, very paper trail driven, very proof-oriented, and so here we are today.
That is the case.
It is the case.
Proof-oriented is what we're here about.
Absolutely.
I will say that you know, in my speech that I give at the beginning, I always ask if, you know, there's a resolution between the parties before we even get up here, in the hopes that I can just issue a ruling. And I don't know anything about the right-of-way case, but looking at the junkyard conditions case, just based on the photos, I want to make sure I understand, are you contesting that there is not something that is a violation under the ordinance? Because just from the photo, if I didn't hear on it, I'm going to hear from both of you.
Yeah, yeah.
But I mean, it looks,
Yeah, no, there's definitely different things, you know, outside of my house that shouldn't be there. You know, like one of the items in particular is a 20-gallon fish tank. It was sitting outside of my door. I believe that fish tank is explicitly referenced as far as like, hey, you have this, you know, junk and crap outside of your home. You should probably do something with that. So, you know, at this point, that tank is no longer there. The, you know, junk was and is very easy to rectify.
exactly.
Julie stated to me verbally that, you know, I recently started a home-based plant nursery here. Got my, you know, official Florida Department of Agricultural Consumer Services, you know, state license. Had Mr. Stephen Jenner come by, you know, got good with him. So I say this to say that there's an accumulation of plastic pots, a sizable accumulation. I mean, probably longer than this table.
I can see it in the photos.
Yeah, yeah.
So, but that actually addresses, so I had thought you've actually answered my question, which was, this actually looks easy. You're saying, no, it's not. And so now I want to at least let the county present its case first, because it's not really fair for me to go straight into.
Can I just finish my real
I would,
secondly?
the reason why I know it sounds like I'm trying to save time,
Okay,
because I
fair.
just want to at least give
Go ahead.
them their shot first,
Yeah,
and
yeah.
then we'll get into that. Please, Ms. Wilkinson.
Yes, sir. This property has a single-family residence on it and is 0.21 acres, zoned medium-density residential. On December 13th, 2024, I conducted an initial inspection and observed multiple piles of vegetation and tree debris, sheets, loose trash, construction debris, fish tank, and miscellaneous junk and debris throughout the property, as well as a large pile of mulch and tree debris in the rights-of-way. On December 13th, 2024, a notice of violation was issued for junkyard conditions and protection and use of the rights-of-way. On December 31st, 2024, I conducted a corrective action inspection and observed that the property remained in violation. As of my final inspection on February 17th, 2025, the property remains in violation. I have had contact with the property owner. Before this case was opened, I had another case for obstruction of the rights of way at a neighbor's property, which while I was there inspecting that property on December 10th, 2024, I spoke with Mr. Novich, who was the complainant, and advised him that he also had the same violation on his property. I did not have a complaint on his property yet, but warned him that if I did get a complaint, he would have to remove all the debris in the rights of way in front of his property. My interactions throughout this case have been very intense, and Mr. Novich has been extremely difficult to work with. He has been combative and refused to remove the obstruction of the right-of-way. He has berated me on almost every interaction I've had with him and has made threats and made derogatory comments on social media about myself, including my religion.
Okay, is there any, by the way, so testimony is evidence in these kinds of hearings, but do you have any pictographic or graphical evidence of this?
Yes, I do.
Are you prepared to introduce it?
Yes.
All right, then I'd like to ask you to show it to Mr. Novich, and we'll go through the same process. So again, I'm looking for objections that you want to make. If you have any objections to these documents. I don't know what they are. But
Yeah. So same as the pictures, same.
Well, it's up to you. I mean, I don't know what kind of objection you would want to make, and I'm not going to limit you. But if you review, I would be curious to know if you have any objections to them for this hearing.
When you're saying objection, I'm taking that as saying either it's true or false.
Well, it's not I'm not your lawyer, but
Okay.
what I'm interested in is information that has relevance for the hearing today.
Which is why I'm surprised that we're discussing her religion.
I think what they're saying, I mean, I don't know what Ms. Wilkinson's...
You're with me. I mean, not to speak for you, but you're wondering why we're talking about her religion on social media too, right?
I just don't know.
Because that has
And-
nothing to do with 7320A, the right-of-way.
Okay. I mean, it certainly isn't relevant for the determination of whether there is a violation.
I
That
agree
is
with you,
correct.
yeah.
Yes.
Okay. So, yeah, what I said on my free time on my social media page would be just that. And so, no, I don't dispute what I've said. Let me double check though, because
Yes, please.
the things that I've seen nowadays is, I'm ready to wake up, man, and just be like, you know. But we're not there yet. Maybe one day. So these are accurate.
Okay. I'll let the county attorney take a look.
So would my cross-examination be kind of cumulative at the end, or?
Once they're done presenting their case, you will have an opportunity to cross-examine them.
Okay.
And then, once that's done, you'll have an opportunity to present your case, including potentially your USB drive, whatever evidence you have. Incidentally, do you have a way to display whatever's on the USB drive? I mean, does it have photos? I'm just curious.
So I have photos, I have video.
Is
It's
it-
on the USB because the paperwork stated that it needs to be on USB.
Okay.
Otherwise, I can't submit it.
Meaning that if it's on a phone or a laptop, I'd have to confiscate the phone or the laptop,
Yeah,
which
yeah.
usually is inconvenient.
Whatever's easier. It's on my
That's
phone.
fine.
It's on this USB. I'm just trying to disseminate accurate information
Okay.
because the camera doesn't lie.
This,
Just for a point of clarification, there are highlights on this exhibit. Ms. Wilkinson, did you put the highlights on this exhibit?
Yes.
And what was the purpose of the highlights?
To only focus on the comments that Mr. Novich has put on social media.
Since this is social media, other people's things show up on the screenshot.
Yeah, other people's things are showing up in the screenshot, but
The highlights are just his
Yes.
comments? Okay.
I'll take a look. Thank you. I mean, Ms. Wilkinson, I just have a question for you about this exhibit. So you mentioned religion.
Yes.
Is this religious or is it political? Or is it both, from your perspective? Because I just can't tell looking. It looks political, and I'm not sure if it's religious, but I don't know.
Yeah, I'm not seeing it as political.
Okay.
I'm seeing it as directly attack of my religion, and because of my religion, he's associating me with terrorist groups.
What is your religion?
I'm a Muslim.
Okay, all right.
Yes.
Well, then, let's see. What I see are comments, about supporting the Muslim Brotherhood. I can't even tell. I don't read Arabic. I see some here. I don't know, but I take it that this is used for introduction of evidence relating to the gravity. If I find that there's a violation, damages or the level of a fine. In other words, it's attacking you doing your job or something that's not relevant for in your opinion, or I perceive the county's opinion, whether there's a violation or not.
Could you state that a different way, please?
I'm sorry.
Correct. This goes to whether or not the gravity of the fine, as has previously been established by Your Honor, the interactions between the violator and code become important. If a violation has been found, it does not go as to whether or not a violation actually occurred.
So that
I understand.
you do understand.
This is about
Okay.
severity.
Okay, all right. So I'm going to admit this as Exhibit C solely for the purpose of the county's case regarding damages, let's say, or what the liability or the fine amount should be, not whether or not there is in fact a violation.
Yes, sir.
Okay? All right, please proceed.
I have an expert witness here, Mr. Laflamme, to speak on the contents of what is in the rights of way.
Okay.
All right, so I saw the pictures. I saw there's mulch and tree debris in the right-of-way. And the section of the code she's referencing basically says anything in the right-of-way needs to be approved by the Public Works Director through the right-of-way permit process.
Were you involved in the prior case that Ms. Wilkinson was talking about? In other words, on the neighbor's case where there was a violation?
No, sir.
Okay. Let me first ask Ms. Wilkinson about that. So what was the issue on the I think it's relevant. What was the issue on the neighboring property?
The neighbor had a fence that was put up in the right-of-way, and she promptly removed it
Did it
after I
go
advised her.
all the way like from the backyard to the very property line on the street, or?
Yeah, it went from midway back through her property line up to about a foot or so, approximating,
And
from
how-
the edge of the road.
And how deep does the right-of-way?
25 feet from the center line of the road.
Okay. All right, so how far, I guess what I'm getting at is past the road and onto the property does the right-of-way?
It's going to be approximately 15 feet.
Okay, gotcha. So about 10 feet from the center line of the road to the end of the road, or the edge of the road, and then
Yes.
about 15 feet, more or less, plus or minus.
Yes, sir.
Okay. And under this code section, let me read the code section. It's usually a good place to start, to paraphrase The Sound of Music. No encroachment, including signs, shall be permitted into existing rights of way except for use authorized by the Director of Department of Public Works. And so I'm looking at the photos, and it's the county's position that the mulch, I don't know what, the wood chips, mulch, is that the only thing that was encroaching on the right-of-way?
No, he's
Okay.
also got tree debris and plants.
The tree debris? I'm gonna show you page 5 of 13. Is that some of the offending?
That is some of it, yes.
What would, well, let me show you page 6. What-
That's showing the height, the level of how much mulch he's got piled up on the edge of the road, on the rights of way.
Did he have an explanation for that mulch?
He's improving the soil quality, because this is the nature coast.
What would he have to do to abate the encroachment?
Have to remove the mulch and make sure it's
Mr.
solid.
Novich, if you would, I'm gonna ask both, we've gotta be fair and respectful to both sides. Go ahead.
To remove the mulch, and if any, the grass has been removed, resod the right of way, make sure it's restored.
If grass has been removed,
I don't know what's
to
under the mulch right now.
resod the right-of-way?
Yes, sir. I don't know what's under the mulch. Maybe the grass hasn't died yet. I don't know. But the right of way needs to be sodded, stabilized.
Would it be a violation if they allowed the sod to die? Is a property owner obligated to resod if the sod dies?
Well, if their actions, if they killed it, they've.
What if they've allowed it to die by omission, lack of watering, I don't know.
Well, if they,
They left a bike, a bike, for 24 hours there, and because the grass under it didn't get the sunlight and water, it died.
well, not just the grass dies and then to a point where it's exposed dirt. Sand is not stabilized, so if it rains, it'll wash down and affect your neighbors. It can go into the road. So that's really what we're looking for. We have to see exactly what it looks like under the mulch to make that
I
determination.
just want to make sure I understand. Is it the county's position under this code section 7320A that there's a maintenance obligation for the right-of-way?
At this point, I think what his argument is that the encroachment is what violated the county code. He has to fix what the encroachment caused. So the encroachment at this point may have caused everything to die, which would deteriorate the stability of the right-of-way and make it no longer serve its purpose. So because his encroachment, his action is what caused the error, the county's position is he has to by fixing his encroachment, he has to put it back to the way it was before he encroached.
If that's true, that's under a different code section. I understand what the county's position is. This is an encroachment allegation. So from where I sit, just so we're proceeding from the same premises, in order to abate the violation, the encroachment, if one exists, needs to be abated, nothing else. There may be another code section. This is the first time I've ever seen a 7320A violation, so this is a matter of first impression for me. But that's where I'll start. So I think what I'm hearing is that from the county's perspective, the mulch, anything that's been added would have to be removed. Is it the county's position that the owner is not allowed to add soil or nutrients or things to the sod on the right-of-way that would help facilitate or grow the sod?
Not necessarily nutrients to help the grass grow. I don't think it'd be an issue with, but filling it in could be an issue. It doesn't look like it right there, but there actually should be swales in that neighborhood. So adding more dirt would make the problem worse. So don't want to add any filler. In
Is there a swale there at that location?
It doesn't look like it. It looks like
Okay.
there may have been at some point because they're not curb and gutter roads. That's typically the two options: curb and gutter or swale.
So you're not able to tell me whether or not this affects a stormwater facility or drainage facility, correct?
Well, based on the pictures, he's built his property up, so that would obstruct stormwater from flowing across the right-of-way in front of his property.
And has the county presented a violation based on obstructing utilities or facilities or anything like that? I mean, this is an encroachment. This is
Yeah, it's
encroachment
encroachment.
of the right-of-way. Okay. I'll tell you just why I'm struggling a little bit before I get to Mr. Novich, is that, encroachment, when we normally deal with that, is like a fence. Like a fence is a clear-cut, boom, encroachment. When you get a survey of a piece of property and we look for encroachments, it's things like monuments, improvements, things that have been placed there. Again, fence is like just the best example, but it could be any kind of structure. If someone planted a tree, that would not be an encroachment. Now, it's possible that, the tree law goes back hundreds of years, but the reason why I'm struggling just a little bit, I'm not saying, one way or the other who's right. As you know, I need to be educated. But if Mr. Novich puts down seed and fertilizer, I'm hearing from the county that wouldn't be a problem, correct? As an encroachment.
No, grass seed and fertilizer shouldn't be a problem.
And so now what I'm thinking, I'm looking at the spectrum. When does it become a problem? I'm going up from seed and fertilizer, and what I'm trying to figure out is, when does it graduate from something that he is allowed to put on his property, but which is in the right of way, and then when does it get to the point that it's not, or it becomes a problem? And I can also see where, if, for example, he put raised garden bed, something like that, would, it's something he's put there. I'm struggling, I'm just struggling to understand why this is what you would consider an encroachment based on what I'm looking at. So help me understand why this is more like a fence and a raised garden bed than seed and fertilizer.
Well, part of why it is different, it is washing down the road, so it is affecting the neighbors. There's some pictures in there we saw is going into the road. So that itself not being stabilized is an issue. Another concern we have is public facilities. There are private utilities in the area. Maybe the road maintenance team's got to do some maintenance. Part of any kind of project in that area would require restoration of the right-of-way. So if utility had to come in there and make a repair, they'd be expected to restore the right-of-way, and that standard is typically sod. That's what we include in our contracts in Public Works. That's what we include language in our right-of-way utilization permit. So if he's got something different, now we're expecting a private utility to bring it back to what he's brought it up to, and it's different from anything else we've ever expected from somebody.
I think something that helps inform, how I interpret this statute, and that's helpful, by the way, is in subsection B, use of the right-of-way for public or private utilities, including but not limited to sanitary sewer, potable water, telephone wires, cable television wires, gas lines, electricity transmission, sidewalks, bicycle ways. And then we go to subsection C, all other work within the right-of-way, including but not limited to roadway improvements, drainage improvements, structures, pole installations, sidewalks, bicycle paths, sign placements. Subsection D talks about parking. You can see how all those things are alike and how this is not like those things. So this is one of these classic first hearing of the mornings issues that I know the county's probably not happy that I have to agonize about, but this is difficult for me. So on the chips, let me ask you this. So if he planted a tree there where the chips are, I'm calling them chips, I don't know what they are, but forgive me. Let's say he planted an oak, and that oak, escaped county oversight or a complaint for 5 years, so it was a decent height. Is that considered an encroachment under this? Now, here's what I want you to think about in answering this. I'm not saying whether or not you would have a right to cut it down, because the county does have a right to maintain right-of-ways. The way I construe that is, y'all generally can, honestly, you can maintain or cut down trees that are in the right-of-way in order to maintain them. I don't really argue with that, but isn't an encroachment under this section?
Can I actually ask a clarifying question?
Yes.
Now, is this a tree that a squirrel put there? and the county just forgot to mow for a while, or is this something?
Tell me the difference.
For the county's position, encroachment is an action that is the owner actively encroaching, whether they're extending their flower beds, they're extending their, where they want to put their plants for their garden that year. Since it's the county's responsibility to maintain those right-of-ways, we can't maintain something where somebody has logs, where somebody has mulch up to maybe 5 or 6 inches
Yes,
deep.
you can remove it.
But it's additional work from the county
I
that
know.
is not normal action that the county has to take, because county that maintains the right-of-ways, they're grass. So now we have homeowners who are encroaching into the county's right-of-way by actively moving these things in there. So this is creating additional work for the county, this is causing our taxpayers additional money, and honestly, depending on what it is they have to move, it could become a safety issue. So therefore, this code's intent is to stop the homeowner from encroaching into the right-of-way the county has to maintain. In this case, he's, for lack of a better term, encroached with his garden, so to speak. Had he put the mulch and the plants and the tree debris out there, and it was within a paved garden area, that's actually come before, Your Honor, before with a paved garden area, and Your Honor said that needs to be removed.
I
The
did.
only thing not here in this case versus the last case is he didn't take the extra time or money or expense to put a little edging around what he's considered his mulched garden area. It's the exact same thing, whether you plant a tree, or you plant a banana tree, or you plant a squash. He has encroached, and now it's the county's responsibility to now maintain that right-of-way, and we have to destroy everything he did, and it's additional time, expense, and possible safety issue for the county, depending on what's in there.
Yeah, I mean,
So he has encroached, like you said, scale of 1 to 10, it might be a 2, but it's still encroachment.
right, and so I do appreciate using the violation scale that I've tried to implement here. It's definitely not a 10, it's definitely not an 8, it's definitely not, but because it is around the 2, I need to understand it. So if, here's why, again, I just want to explain. I mean, if you pot a couple flowers there, it's still no functionally different than digging up the dirt or sod that would be there. And so what I'm struggling with is the fact that it's mulch. It still would just have to be dug up in the same way as sod or the flowers. In the prior case, which I remember, they were substantially raised trees and it was a landscape.
It's like the poured curving thing
Yeah,
going on.
and so all right, so I think I understand the county's position. I'm now going to turn to you, Mr. Now, you have an opportunity to cross-examine the witnesses if you wish.
Am I free to, I guess, make different points as I see and then cross-examine?
No, I mean, the way that it works is that they've presented their evidence, so you can cross-examine them based on the evidence.
Okay.
And ask them questions about what their testimony was and the documents they've given me.
Yeah.
And then once that's done, we move to you to present your defense. And you can make argument.
Okay. Are we able to show the evidence on these screens?
I don't think so,
Okay.
but I can give it to you to ask, as a frame of reference. I'm now
If you
show-
can just ask Julie to just point to where I'm having an issue with Muslim people. Let's start with that, because I don't want to, for my name to be slandered publicly like this is very serious.
Okay,
And
so
since I have not disputed the veracity of those photographs, what we're not going to do is then mislead the public as to what is contained in those photographs, which is ironic because that was on social media. But just so everyone's very clear, because I'm very specific with my words, I have a background working in claims. I don't just say things. I'm extremely careful. And sometimes that, I think, coupled with my direct nature, gets perceived as, I'm this hostile person, which I'm not, They say if you have a garden and a library, you have everything. you know, or you're a rich man, or however the saying goes. Like, that's what I do.
Well,
I literally have
let's-
books and.
you have the right to cross-examine, so I think
So,
what you're
yeah, I'm sorry.
asking is, on exhibit, I mean, this is the flip side to introducing this as evidence. So your
But-
question, so this is where you actually would ask them the question directly. Normally, I ask that the parties speak directly to me, but
Well, I thought that there was something like, don't even address the people.
there
I don't know if
isn't.
they're saying
There-
try to have decorum and not animosity.
Well, if you're presenting your case, but this is cross-examined, so you have to speak directly to the witness.
Okay.
So I guess I'm trying to just facilitate this so we can get to a resolution. Your question is, what in this Exhibit C reflects a commentary or a criticism on Islam?
I'd like to clarify it. If you could read the comment out loud, Julie.
I'm not going
Well,
to
yeah,
read
yeah,
it,
I'm saying,
yeah.
Julie, if you can go ahead and read the comment out loud that essentially endorses, you know, my dislike or issue with Arabic people.
Ms. Wilkinson, would
because I
those-
speak Arabic and.
Ms. Wilkinson, would those be the highlighted comments?
Yes,
Okay, is it your understanding that the answer to that question would be the words that are highlighted in Exhibit C?
Yes, well, I never said that he had a problem with Islam, first of all.
Okay.
My issue is that he's putting it out there and associating me with terrorist groups.
Is this like, I ask a question, she talks to you, I ask a secondary question, because I'm not trying to break decorum, because I'm
No,
experienced
you
in
can
that.
ask the what questions would you like to ask?
Yeah, so, so earlier you clarified if my issue was in regards to religion or political, to which you replied that it was religion. So that's why I'm just trying to confirm, where is my problem with the religion, colloquially known as...
She's already given you that answer. So she says that that's the highlighted stuff in this exhibit.
There's multiple things highlighted,
I know, but that was her answer. So, I mean,
Okay.
you can look at it if you want.
Are you
I
able
don't-
to read that?
I don't want, I'll read it. I'm just trying to accelerate it. I'll read it for
Yeah,
you if you
I
want.
mean-
Okay. So comment from Michael, is it Novich?
Yes.
Novich. Allison Darby, because of you, I will now reach out today on her openly supporting the Muslim Brotherhood. Hopefully we can investigate this. I'll let you know how they reply back. Keep talking. Michael Novich, Curtis McCown. Search her name on Facebook if you really want to be shocked. Her cover Facebook picture is openly associated with the Muslim Brotherhood to Lowell, who is aligned with Hamas and other terrorist organizations who all want death to the West. Michael Novich, her lack of, I think, in parentheses, competency, should be grounds for a write-up or better yet, terminate, considering her public support of Muslim terrorist organizations. Who hires these people? Michael Novich to Christian Blanchard. No kidding. I'd like to find where she parks and grab that VIN too, just because I can. Some of these folks need a gentle reminder, it seems. Of which I have a question. A gentle reminder of what?
What our rights are. And I understand how that can be perceived as a certain type of way, but knowing your rights, when you're in the public realm, certain things are public information. If somebody came up to my car in a parking lot and took a picture of my
Your
windshield,
VIN?
my VIN. Yeah, well, the VIN is in different places.
Yeah.
So if somebody does that, or even consequently takes a picture of your
What do you think they
license
want the
plate.
VIN for?
I don't know. I mean, it's.
I think I've got a guess.
I think that really what a lot of it comes down to is power and authority. People are just trying to fight back in any way they can. This is why children have such an issue with food. They're picky eaters. They're just trying to retain some of that power and some of that control. I've sought nothing but what's the word? A resolution, compliance, and just trying to move forward. I'm really not trying to drag this. I'm very fiscally conservative. This woman spoke about our tax dollars. I mean, I'm not getting paid for this.
So, Mr. Novich, you did answer my question. I'll continue doing what you asked me to do.
Okay.
Michael Novich, Bobby Glass. They get paid for special master hearings, so they're incentivized to drag it out to those depths, are they not? Her being an open supporter of the Muslim Brotherhood is just icing on the cake. Michael Novich, Allison Darby. No need to imagine. Come on out in real life and see. Walk to the bottom of the hill on my street and tell me what you see there. You're supporting an incompetent government hypocrite who supports the Muslim Brotherhood openly. Why? So those are the comments that
Okay.
are
Thank you.
at least perceived to be attacking her
Okay.
religion.
Julie, are you aware that you're currently being investigated by Steve Howard and Eric Head due to that?
Objection, relevance.
She brought it
You
up.
guys introduced this into evidence. You can direct, your witness not to answer, but I mean, I don't know what the relevance is because we're now opening a can of worms.
I was totally surprised that she brought this up. I wasn't going
What
to.
is your question whether or not is she aware that she's being investigated from?
Yeah, just yes or no.
persons- Wait, regarding the comments that were just read,
Yeah, regarding the Muslim Brotherhood affiliation.
who are the people you identified?
I don't understand.
What can you repeat the names?
So Steve Howard,
Mhm.
I believe that's his name, Citrus County admin, and I believe Eric Head
Okay.
is on that email as well. So just
Okay.
are you aware that you're now formally, per Steve, it's off to HR now, as far as your open support to, the Muslim Brotherhood, or at least my perception of that. Because my word isn't law. I'm just a,
What does that have to do with? They've introduced.
Again,
I
why
know, but here's the thing: is they've suggested whether I agree with it or not
Yeah.
is open, but they've suggested that you're attacking a code enforcement officer for her religion when she's trying to enforce, again, whether right or wrong, the law.
Yeah.
And personally, I think there's an argument to be had. You can hear. I think there's two sides to this.
Yeah.
So.
We haven't even, and I'm not trying to take all, I have stuff to do.
But whether or not someone's being investigated is irrelevant to whether or not, do you understand that? I mean.
Yeah, so the county brought up her personal thing as far as evidence in the case as it pertains to the target on my back in 66 South Columbus Street, which is where I live. So that's why we're now talking about Muslims and the Muslim Brotherhood and Islam here in my small town, Citrus County.
Okay.
So, I mean, it was just a yes or no question. Are you aware?
I don't think it's relevant.
Fair. Well-
I want to let you continue to cross-examine, but
Okay,
I actually do agree with the objection on that. Yeah.
okay. Do you have evidence showing anything going downhill?
I do. It's in Exhibit A.
Okay.
The photos were taken on February 17th.
So it's your testimony that in answer to his question, there's evidence from February 17th, photos on February 17th, that there are things going downhill. I think I understand. So you've provided photos that, from the county's perspective, and that's why there's photos of other properties.
Yes.
I see. Okay, and I do see the chips.
Okay. And so are we to assume the precedent that stuff going downhill is a violation of 7320A, which is right-of-way, or would that be illicit discharge?
Objection, mischaracterization of the evidence.
I'll allow it.
I'm sorry. State your question again.
Oh, I'm sorry. So now that we've established that stuff rolling downhill is problematic, we'll just use that layman's term, would that be problematic for 7320A, a right-of-way violation, or would it be problematic for illicit discharge? Or perhaps both?
So I believe it would be problematic for an illicit discharge. It's not to say that that's the reason why I've given him the obstruction of right-of-way violation. I believe the right-of-way violation is existing, but it's just for the supports why we can't have stuff in the right-of-way like mulch that's going to freely flow down.
Please continue.
Do you think that leaves float with water downhill more easily than something like mulch does?
I would say leaves would float downhill when water is flowing, if the water catches the leaves, yes.
Okay. I agree. It's only logical. Do you recall me directly asking you if leaves are a problem in the right-of-way?
Yes, I remember you asking me that.
Okay. Do you remember what you said to me?
Please remind me.
Is the answer yes or no?
No, I don't remember.
Okay. No, you can continue your cross-examination. She doesn't remember.
I'm just so like disappointed.
You'll be able to testify as to what your recollection is, just like
It's
I haven't
just-
asked, but I will ask her to characterize your conversations. But you'll both be able to say what the other said.
Do you remember me? So on January 28th at 9:40 in the morning, you came by and we talked. And this was before things further broke down, we'll just call it. Do you recall that conversation and that day?
I recall a conversation. As for specifics, there was a lot said. So what exactly would you like? Yeah, I recall a conversation, yes.
Okay. On that day, did you feel that I was trying to comply and seeking genuinely to figure out how to comply with the state or the county here?
I do not think so.
Okay. When you came by, did you notice logs, sizable logs, maybe the size of this table in terms of width, that were bordering a plant in the right-of-way, sugarcane, in addition to mulch that was in the right-of-way? Did you observe those violations?
Yes.
Okay. Did you point out to me as far as the beginning of that was essentially, I've made a lot of progress and I'm moving in the right direction, but I'm not quite there yet as far as compliance?
Absolutely, I said that.
Okay. Did you then say that those logs around the sugar cane was problematic?
Yes, I did.
Okay. When you said that those logs were problematic, did I immediately pick those logs up and move them past the right-of-way threshold, thus seeking compliance?
Yes, you did move those logs only.
Does this immediate action that I took not directly contradict your claims of my supposed hostility, aggression, and not seeking to comply?
No, it does not contradict.
Can you briefly explain how you see that?
I'll be the judge of whether it is or it isn't.
Okay, fair. Do you recall me seeking to record our conversation
Yes.
openly? Okay. And did you have a problem with that?
Yes, I did not want to be recorded.
Is there?
I did not want to be recorded being verbally abused by Mr. Novich.
So on the video, I actually yield to you during a verbal collision. And you get to basically lead. I don't hold you there, so I guess that's not really a question, just a strange perception of reality. Maybe the threshold for abuse is very low. Is there, the county's Kimberly Harrison mentioned as far as intent, which intent does matter very much so. Is it not the property owner's responsibility of essentially what is on their property, regardless of intent?
I don't understand what you're asking me.
I actually don't either.
So this was regarding if a tree is intentionally planted or if Mr. Squirrel happens and it's unintentional fallout.
And your question is, does it matter?
Yeah, I don't think I ever got clarification on that.
I think that's a legal question that this is based on fact. So the idea is to cross-examine based on.
So I'm just getting ahead of myself.
I think so. I think that's a legal argument you'd make to me.
Okay. Does the county have a current definition of encroachment?
I would have to defer to the expert. Joanna Katu is our land development expert.
Ms. Katu?
Is she here?
She is.
If you want, I mean,
Off the top of my head?
yeah, I mean, I don't know.
Not that good, so.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
There may be a definition in land development code. If not, it defaults to Florida statutes and then further defaults to Webster's dictionary.
Okay.
I
all right.
don't know off the top of my head if there's one in there.
Okay, thank you.
Thank you.
So, Ms. So you're deferring to the county's other on what encroachment would mean? Okay.
Which is,
Well, they're saying there might be a definition in the land development code. If there is, they're gonna rely on that, which I'll have to look up. If it's not there, then they defer to if there's one in the Florida statutes that would apply. And if that exists, they'd rely on that. And barring that, if there's no other definition of encroachment, then the plain meaning of the word will control, and we would look at a dictionary to ascertain what that is. So, for example, I will read now, let's see, let's check it out.
There is not a definition within LDC
Okay.
Chapter 1 for encroachment. Webster's Dictionary does have two definitions.
I mean, this is just quickly what I'm seeing, which is, I'm not holding myself to, but it says something, according to Merriam-Webster, this is from the AI, and you know, they're always trying to game me, but according to Merriam-Webster, encroachment is the act of gradually entering or taking over another's rights or property. It can also refer to a structure that is built on another's land. So that's just what I see off the top, but I don't, let's continue.
yeah, do you agree that digging through mulch is easier than digging through compacted turf grass?
Objection, relevance.
I'll allow it.
I do not agree that digging through mulch is easier than digging through grass.
Okay. As someone who owns a landscaping company with years of experience, I will just say that we'll agree to disagree on that. If other members of the community are walking down the street and utilizing the right-of-way, do you agree that the right-of-way would not be encroached, or how do you see this?
Objection, compound question.
Go ahead.
Are you asking me if people are allowed to walk on the right of way?
No, I'm asking, assuming that people, say, and their dogs, were to walk on the right-of-way, as this area doesn't have sidewalks, does the utilization by that other community member and their dog not just demonstrate that no encroachment of the right-of-way has occurred?
I think actually you did understand the question the first time.
So people can walk on the right of way, and you're asking if they're on the right of way, is that encroaching? Like while they're walking their
So,
dogs?
Mr.
No?
Novich, I think what he's saying, I think that's an argument, Mr. Novich, not really a matter for cross-examination. Let me explain. You're basically saying,
All right,
well,
okay, all
if
right.
people, there's no sidewalks, people
Yeah,
are
yeah.
walking on the right of way,
Okay.
doesn't that show
We'll
that
switch
it's
it up.
not an
So-
encroachment? No, sir, no, it's not the way it works. So I'm not done. So I think what he's saying is, that by virtue of someone walking down the street in what is the county's right of way, but they're walking on the grass, doesn't that show that just by them walking on it, that that's not an encroachment? There's no, I don't think that's really, it's not relevant for your determination here, so that's why I'm asking Mr. Novich to continue.
Okay. I understand. Do you recall telling me, I believe this was on one of the earlier visits, I think it may have been on January 28th, I'm not positive though, but I'm pretty sure. But do you recall telling me that the right-of-way needed to be, quote, grass only?
Yes, I said it needed to be grass.
Grass only? Or no?
Objection asked and answered.
It wasn't answered.
Grass only? It may have said only, but that wasn't if I did, that wasn't the intent, only grass. You need soil as well, so you can't only have grass.
Please
Which was,
proceed.
which was part of my confusion at hearing grass only, which led to then,
You think she meant that you could
Leaves.
just put grass there with no soil?
I've never been in a situation like this. And while I like, confrontation and that kind of thing, I really don't like this. This is not fun, this is scary.
No one here does,
So I'm really not trying to assume,
except for the lawyer. He likes it.
well,
He likes it.
some of us are getting paid for our time here. I'm not one of those people.
Right.
I was shocked to hear that you come from Orlando.
Actually, I don't bill for travel. Miss Wilkinson, do you get, he mentioned in the comments that y'all get compensated for attending the hearings. Is there extra for attending?
There's no extra. I get
Okay.
paid by the hour, and this is part of my
Okay.
job description.
Okay, all right. I was just curious.
Overtime pays. So, but yeah, as someone who has worked in claims, I'm very particular. Words have meaning, and this is important. And when people use words like they're free, just throwing words around, it can have certain outcomes. And so that is why I am the way that I am. My life has made me this way. And so when you say grass only, I don't know in what other world I would take the word only than the meaning of only. Furthermore, I attempted to clarify the point by talking of leaves.
Well,
Do
you're
you-
testifying now. Yeah, let's
Yeah.
get back to
Do
cross-examination.
you recall me seeking this clarification as far as is it only grass or are leaves okay?
Yes, I recall that.
Okay. At this point, all I wanted was an answer. Are leaves okay? I still don't know. No one does.
Okay, I think the question is, do you consider leaves an encroachment?
I think there would be a difference if a pile of leaves were purposely placed there than if the wind had carried some leaves off of a tree and they had happened to land in the right of way.
All right.
Does our stormwater system getting destroyed care about intent?
No, I accept as a truism that it does not.
Okay. I'm sorry, I forgot your, it sounded like you basically said a pile of leaves. Okay. So subjectivity is a thing. Not all piles are the same. So at what point, so with grass, we have specificity. I know if my grass is over 18 inches, I'm in trouble, or can be. What is that as it pertains to organic matter here in the Nature Coast, where we talk about nature live in harmony on the wall, and then over there it talks about the protection of environmental assets, and then before you walk in over there it says something about nature. So at what point is organic matter a problem? I guess we'll call it. At what point, what's the threshold for that pile? Is it poundage? Are we going to measure the pile? Is this uncharted territory?
Again, I'll answer that. I don't think this is a proper, I know what you're getting at. I think academically it's interesting. It's not a subject for
This is
cross-examination, but, so for example, on your 2031 violation, it talks about accumulation of junk, debris, rubbish, and vegetative matter. There is no weight limit. There's no size limit. It is a subjective determination that I make as to what constitutes a level of vegetative matter that is an impermissible accumulation of it, if that makes sense. And I don't think that in this case, what they're saying is that based on this evidence, it is an encroachment. In other words, I think your question is more towards 2031, but I think you're trying to talk about the right of
So
way.
what's happened here is I'm written for one thing. I'm being verbally threatened for illicit discharge, which is interesting because I've been doing this for 3 years. And Citrus advertises on the website, Citrus Bach or whatever, supposedly that they proactively manage and look for illicit discharge. I was put on the front page of the Chronicle, like back in August, for this, for Food Forest stuff. Half the community loves me. It was no secret what I'm doing. And so if we're even going to try to get me on illicit discharge in the future, then I would just be wondering, well, gosh, why is it that my mulch wasn't, say, a problem for years and years? And,
Well,
I guess that's almost a waste of time to think about. But.
It is, insofar as there are many cases here where people have been doing something for many years.
Yeah.
And then a complaint comes and it becomes, subject to the
So
code
is me
review.
trying to establish precedent or a defense against illicit discharge that I feel would come in the future, that's a moot point right now?
It is.
Cool. All right, so. Yeah, I mean, their evidence don't even line up with what they're saying, so I don't even know.
Mr. Novich,
If you want I think I'm done with cross-examination at this time. I have a USB.
One of the issues in this case, and I recognize this is difficult, is that both of you have talked about a decayed communication channel, in other words. So it doesn't seem like there's any dispute that things have gotten uncomfortable, in the conversations. And obviously we're talking about someone's property. This is not uncommon in the code enforcement context. But I want to give you an opportunity before you present your case. I mean, what do you mean by decayed? How bad have things gotten? What have you told her that, because I'm going to ask her the same question.
Yeah. So code has came out before. When I bought this property a little over 3 years ago, it was grass only. And just so everyone knows, that's terrible, for the nature coast. There's hardly anything that lives there. Me and my property, I see native green anoles, native southern toads, all types of birds, and dude, it's like a zoo. It's awesome. Other code people have come out. We've been able to resolve it amicably. Julie even told me, she's like, yeah, I like what you're doing. I kind of, nature coast, she's with nature, supposedly. I don't know how. I'd almost begged her. I'm like, please, just, you got to give me something. I gave stuff. That's why I started moving logs right then and there. She's like, oh, you're making good progress. You got to move this, you got to move that. Dude, I picked those logs up right then and there.
What I'm asking is, how did things decay? What
So
am I going to hear
okay.
that's unsavory?
So, nothing.
Okay.
You've seen the unsavory, and guess what? That's truth, and I don't even care. Everyone should know it. You want to work in the public? You be in the public. And she's free to leave and not be recorded in public, but it's so weird to work in the public. We're being recorded right now. Why she would be okay with being filmed here but not talking to me in front of my house is just, it's non sequitur. It's inconsistent. So I had one last clarifying question. So really all I would like to do is plant native plants here in the right-of-way, in the nature coast. Crazy, I know. So much so that I emailed you guys, including J.C. Charlton, your boss, trying to just get someone in writing to say yes. Yes, Michael, you can plant native plants in the right-of-way. So far, no one's told me that. So this is basically going to go one of two ways. You guys can formally say, yes, you're allowed to plant native plants, provided they're ground cover, right? Not
Is
trying
there
to put
a question?
Yeah, there is. I'm sorry. So I'll wrap it up. Am I allowed to plant native ground cover in the right-of-way? Or is that a violation?
Is that an encroachment? If he puts some kind of native Floridian plant in the right-of-way,
Ground cover, which is a substitute to grass.
is that an encroachment?
I did ask this question to the director of the technical services, and he said it needs to be grass because he would like to plant Mimosa strigosa, which is a beautiful plant, but the director said it needs to be grass, so that's what I defer to. It has to be grass.
Okay, all right, question answered. Now, here's what I want to know before I allow Mr. Novich to present his case, and I think there's probably people here missing work for this. So I want to try and, we may need to figure this out, but Ms. Wilkinson, is there anything that you just heard that you disagree with from Mr. Novich's testimony? Because he, in other words, he said that, you know, we already have seen whatever's been unsavory in terms of the communications. Is that accurate?
Yes, that's accurate.
Okay. Well, I'm just surprised because you both testified to a decayed communication channel, but there was there was nothing where there was something like, curses or something in the front yard.
He's
all right.
never cursed at me.
Okay.
He's never said anything derogatory towards me in person.
Okay.
But he gets very loud and uncomfortable, and the pressure, the feeling, it feels unsafe. So that's why I leave when he's recording me.
Okay. All right, so now, how long do you think it'll take to present your side of the case, Mr. Novich? I only asked.
I almost want to know, how is this, like, what is the process? I don't even know where I am. Are you a judge? Like, what happens next?
Well, you're here at a quasi-judicial hearing, so both sides get a chance to present their evidence and argument regarding things, and the county's presented its case regarding the 2 violations against you, and now you have a chance to present evidence. I am clothed under the law with the authority to make findings of fact, so I can.
So are you able, I'm sorry.
I'm almost done.
Sorry.
I can determine whether or not the facts have been proven to justify that there's a violation in each of the cases. Based on that, you can appeal me to a real judge, or not.
But you can't tell me basically, like, you know, I don't understand how it can be legal to not plant a native plant in the right. We have FFL legislation that incentivizes our water
Mr.
district.
Novich, let me tell you, I don't know either. That's not the case before us, though. That's a different fact
You're right.
pattern.
Okay.
So it may be relevant.
Well, hopefully we can get some.
You know, whether planting something like that is an encroachment, you know, that'd be a tough one. But that's not the case before us. So what I'm curious about is, you brought evidence, you have a USB.
Correct.
How many photos or videos are on that?
It's just a couple of short videos basically showing her not wanting to be recorded. It's like a 17-second video where I'm basically just saying, hey, are leaves allowed in the Nature Coast? She's like, I don't want to be recorded, and she drives off. Another is literally a picture showing basically the road, you know, breaking apart, you know, because if we're going for future, can't talk about illicit discharge, although she can basically threaten me orally about it, so that's cool. So I'm just trying to get clarification as far as, you know, the road breaking and, you know, falling down the road. Is that illicit discharge, and am I going to be blamed for that? Because
This is not an illicit discharge case.
Fair, okay. So is the broken road, I guess, part of encroachment? We can question that, and then there's also some emails where I'm basically seeking guidance as far as, hey, can I plant, you know, natives? Is it allowed? Is it not allowed? This is regulation by enforcement is what's happening. They won't tell me what's allowed because they don't know. So I'm trying to find the law or the line, because I am trying to be compliant. You know, that is the goal. That's why it's like, guys, I'll comply right away. I told her, I said, I have time. I have time to do this. Just tell me what I can do. And their response is literally, in this case, remove the whole ground. Remove the ground. Remove the ground.
Well, you've already heard I disagree with some of the county's particulars, but the case they've brought is based on this mulch and the logs and things like that.
Yeah,
So I'm not going to engage in hypotheticals.
yeah. Well,
And,
so at this point, it's mulch only, you know, in the right of way.
well, to that end, Ms. Wilkinson, I have a question. So
Yes, sir.
on Exhibit A, I see kind of like a demarcation line with logs and a sign. Is that 10 feet?
That's in the right of way.
So the logs and the sign are in the right of way?
He has moved the logs, I believe. The sign is, I
Okay.
believe it's still there. I'm
So
not
I
quite
see-
sure.
Is it the county's position that at this point, the photos I see from yesterday, the material that is still encroaching would be chips and maybe an accumulation of vegetative matter?
Yes, can I come up to you?
Yeah,
to-
I just want to know what the violation is as of today from the county's perspective.
So this fence is going to be the right of way.
From where the fence is,
Yeah.
that line?
And then about to where the back of this car is the other side of the right of way. So all of this is all right of way.
Okay, so what Ms. Wilkinson has just shown for the record is looking at page 7 of Exhibit A, for case number 24-2133, is showing some logs that would still be within the right-of-way. And so originally, I take it the fence went a lot further than that.
Yes, it did. The fence, that case abated. She moved it back.
All right, now I think some of the evidence you talked about, Mr. Novich, is relevant for mitigating circumstances. In other words, the county's presented evidence that, you know, you're attacking a code enforcement officer. Some of the evidence you've talked about in terms of asking what complies would probably be mitigating evidence. In other words, evidence that you are trying and fix it. But I have a hard time admitting it if I can't see it. In other words, like if there was some way to see it on a laptop or something like that, if
See
that makes
what?
sense. The videos, I don't know. Frankly, I think it's redundant and cumulative because I think you've represented everything that the
Okay.
videos will show me, if that makes sense.
Well, it sounds like it doesn't matter because this isn't court either, so.
It definitely is not court, but you have certain due process rights, meaning that you have to have an opportunity to be heard. I can't just shut you up, if that makes sense, you know. They do in a lot of code enforcement courts. So is there anything you want to present on this beyond what you've already testified to? In other words, do I have enough to make a decision from your perspective at this point? And I'm going to hear from the public, but.
Well, I definitely reject the use of the word attack. If I attacked a code enforcement officer, we would know that. No attack has occurred, and there's no planned attack. I have stuff to do. I'm literally a gardener. I have chickens. I have tilapia, and I give people free plants here in the Nature Coast, which is why people appreciate me. How that has been misconstrued and, you know, that kind of thing, you know, I guess maybe it is partially me. To try to answer you in a quick fashion, I guess I'm just almost hesitant to even like what happens after this. So
It depends on what I do. And so if I find that there's a violation, I would assess an amount of time
Okay. So-
to bring it into compliance before any kind of fine begins. So I would, for example, there's really 3 things that might happen today. One is I find a violation.
Okay.
I give you a certain number of days to bring it into compliance, and I say what the fine is going to be per day
Yeah.
until it's brought into compliance.
Okay.
So if you do it within the 30 days I allow, hypothetically, no fine, this goes away. If it doesn't, then a fine begins. Okay, that's one way. The second way is I find that you prevail on one or more of the cases, and there is never a fine. I ratify your actions. The third thing that could happen is I continue and ask for briefing from the parties on what constitutes an encroachment. Huh?
I said tempting. No.
Not to the county, but to me, because I want to make sure I make a right decision. So those are the three possibilities.
Same. I would definitely love for you to make the correct decision as well. The only last thing I guess that I'll clarify is that the photo is at a bit of an angle, and that angles in photos can definitely be distorting, as we see with fishermen holding their fish out like this. So there are currently no logs or heavy things that exist in the right-of-way at this point in time, and we know that because I moved them when she pointed them out.
I think I see the logs that you moved.
And I was shocked that she dug in heels and basically is saying that mulch is the problem. So, I mean, I've almost joked that this is almost like mulch versus Citrus County, is almost what this is. I'm just the vessel or something, but, and what's crazy is our water district incentivizes us for having less impervious surface. If they were so worried about stormwater, they would not want people to concrete, right? And so what we're going to do is this is either going to be native plants here in the Nature Coast, or I will file and permit and pay the money, and it will become impervious surface, and it'll just be more concrete. And that won't be on me, because I've offered it's not even a compromise, it's my desire. To just plant native plants, especially ground cover. We're not talking
I think you've made your
trees,
case. So
you guys do what you want, and I guess let me know.
I want to hear from members of the public. Is there anyone from the public who's come? Ma'am, please feel free to come up and.
Ma'am, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Can you please state your name?
Sharon McInnes.
Thank you.
I am the unfortunate neighbor that lives next to him with the big bad fence. The happiest days of my life are when my fence went all the way down. It's Mr. Novich threw a temper tantrum running outside my front door. It's blocking right away. So I took it upon myself and within the time frame did what I had to do. Met Miss Julie, very professional, kind woman. The police were at my house probably 3 different occasions because of his temper tantrums. My son has had to confront him. You talk to my mother one more time about this lawn and screaming at her there's going to be a problem. 8-foot flame in the backyard from fires. I've had to call the fire department. And the manner in which he attacked Miss Julie with his camera going right at her and filming her was absolutely disturbing. So this guy is violent, and I did not bring the police that I've called several times into it. I will if I have to, but I've brought to his attention, this yard looks like crap. Can you take these logs and do something with them? You're always bringing your mulch guy and dumping bucket loads of leaves and branches and mulch and logs, and he then throws his hands up, throws a temper tantrum, screaming and hollering. The neighbor across the street, the old man, has threatened to put a cap in his ass if he doesn't calm down. The neighbor to the right of me, who is
Is cursing allowed?
No, hold on.
Sorry, I'm
That
sorry.
was a quote. Go ahead.
Quote, yes, the neighbor to the right of me, who is a disabled vet, was happy I put the whole fence up, so he didn't have to look at this in his front yard. But I just wanted to make you aware, and the manner that he approached Miss Julie with that camera and that filming was disturbing. So I just wanted to let you know, and then placing it on Citrus County word of mouth. And it popped up on my Facebook. I've removed it since, but just to let you know, the times the police have had to be involved because of the argument between him and I and his screaming and temper tantrums. So that's all I have to say.
All right, thank you.
You're welcome.
Is there anyone else from the public who wants to be heard on this case? Okay, I see another person.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help
Yes,
you
ma'am,
God?
I do.
Please state your name.
My name is Paige Martin, and I'm here as someone who has also, I'm in violation of a complaint. And I want to just take a second, if I may, since you're allowing. I am a biologist by training and trade. I'm a 30-year civil servant, prefer not to mention the agency. And I would like to apologize to everyone else here for the way this is going, because this is not how it's supposed to happen. Yes, native ground cover would be spectacular. I would love it. But that's not what the law is, and that's just what I wanted to say. Right now, we need to work through how to get what is in compliance, because that's my own issue. Get to what's in compliance, and then take the proper steps to get what you would like to do. And I'm representing the people out here because we've noticed.
All right.
Thank you, sir.
Thank you. Is there anyone else from the public who wants to be heard? Okay. So usually, Mr. Novich, I do give you a chance to respond to the public comment if you wish. What response would you like to make? If any. You don't have to.
I try to be a good citizen, which is why I have not incurred any infractions that I've had to pay for, which is unlike Sharon McInnes, my neighbor, who is cited for chronically at-large dogs. I know this is a bit unrelated, but take things with a grain of salt.
Okay. Let me just look through the photos here.
And for what it's worth, I would like to submit what I have. I mean, I literally went out and bought this. I felt good about myself for being detailed enough so as to read what I was given and to, you know,
Right.
come prepared.
Yeah, maybe we should clarify in the pre-hearing order that if you do come with a USB, there should be a means to play it, which I didn't do. So it's up to the county.
Am I able, I guess, to... The main thing that's almost of most important in this...
Ms.
it was-
Harrison, do you object to the USB if it contains what's been represented on the record being admitted into evidence?
Can I ask one clarifying question?
Yeah.
In the emails you communicated to the county, were any of them to the Director of Public Works?
Who's that person?
So you wouldn't know.
I'm asking for a name.
Carlton Hall.
That name doesn't sound familiar. I don't believe so.
I would object to the items. The videos are cumulative and not relevant to the underlying issue. Additionally, the photograph you indicated was of a road. There's no relevance to the current action. We're not here on something he did that's causing road deterioration. And per county code, which I believe is in his notice, but I don't have it in front of me to know for sure, if he wants to put things in the right-of-way, he had to reach out to the Director of Public Works, who is Carlton Hall, and by his statements, none of the emails are to the person, therefore they would not be relevant.
Well, but some of the emails are regarding your attempt to comply or...
Yeah, this is all corrective action related, reactive on my part. Basically where I'm saying, hey, tell me what to do.
I'm not sure the videos actually help you, so I don't have an objection. I think they might help the county based on what I've heard about them. So I don't know why you'd want to put them in, but I'm not going to object.
Maybe there's confusion. I'm just part of...
I'm almost done. So what I'm going to do is I'm going to allow you to introduce it into evidence solely for the videos, the photo of the road, and the emails that you represented. I will allow that to be introduced into evidence. Okay. And what I'm going to do is I'm going to make a ruling in one case and not make a ruling in another case. Okay?
Okay. We're not looking at this then, or I guess
Well, I accept it. I'm introducing it into evidence. It'll be a part of what I eventually find in the other case. I am going to find that there's a violation in case number 24-2117 regarding code section 20-31A. I do find that there is a accumulation of junk, and so Mr. Novich, the problem with this stuff is that I think you're allowed to have planters. I think you're allowed to have,
I was basically advised from Julie that the pots are okay.
Yeah.
And at this point, I mean, that's almost exclusively what's in my carport. That fish tank we referenced is gone. I'm
Yeah.
not trying to live, you know.
so that's the only thing I'm doing is I'm making a fine, because I think that's easy. I do think that there's just, on our violation scale on this, it's probably a 2 or a 3. But it does need to be cleaned up. I'll give you 30 days to do it. What's the county's recommendation on a fine if it's not brought in compliance in 30 days?
$100 per day.
Okay, $100 per day, about as low as it goes. All right, and then I'm sorry to the parties, but in case number 24-2133, I am going to not issue a briefing order. I don't think I need input from the parties, but I think I have to look into this. I don't know if it's an encroachment or not based on what I'm looking. I also think that it would be helpful based on what I've heard to explain from my perspective what I think an encroachment is, because it sounds like this may recur and that the parties may need guidance, for better or for worse, what I think. I will issue that order at the next hearing, which is potentially problematic because I won't be here in March. So are you having a hearing at all in March? You're just pushing it? So that's going to be a doozy. I'll issue the order in person because I think I have to do so under the law at the April hearing. You don't have to be here, but I'll be issuing the order at that time, where I'll say whether it's a violation or not, and I'll give you guidance on what I think an encroachment is.
So
Make
you're-
sense?
You're doing research?
Yeah, and I'm going to review the evidence you gave. I will do research and write an opinion.
More than anything, I just want an answer.
I'm
You know
going
what
to
I'm
give-
saying? I don't.
I'm giving an answer now.
Yeah.
Even if it's in
No,
your
yeah.
favor, the county might appeal me. Maybe, and maybe the judge thinks I'm wrong. Vice versa. You might not like what I have to
Yeah.
say. You can appeal. So,
Yeah.
If we could get the USB from him.
Yeah,
There's
we have
that.
to turn that
And
over.
if I can clarify, I guess, as far as the junk, just because earlier it was almost kind of implied like the stuff is a little bit bundled together and even some of the evidence, the photos.
Mhm.
I just don't want this junk to stick and then it still be, well, now it's junk because it's mulch. You see what I'm saying?
The mulch case is not subject. I don't consider the mulch part of the junk case. Is it? No.
I do not.
Okay.
But we are aware that the tree debris in the
Yeah,
back-
I'm about, so can we
Yeah.
just clarify then, I guess, what is the junk or what I would need to do? I'd
You've
like to
gotta-
go home
You've
and
got
do
to
that.
clean anything offending within that's subject to the junk. So here's what the code section says. It is unlawful for the owner or occupant of any land to permit, cause, or have thereon any accumulation of junk, debris, rubbish, and vegetative matter, except junk stored in enclosed litter receptacles, et cetera, et cetera. What is your opinion of what qualifies under this case?
So for the junk, he's got a whole bunch of tree debris out there. He's got some tools, not the yard tools, but he's got like a dolly thing. I believe he's got, can I take a look at the photos from,
Because what I'm going to do is I'm going to specify in my order what is
Yeah.
specifically subject to it.
I can't have a dolly in my carport?
You can't have unused, discarded items that aren't enclosed. So, for example, a dolly, excuse me. Oh, it's in there, sure. So if we look at the definition of
I don't,
junk shall mean any abandoned property, construction and demolition debris, litter, waste materials of any kind, used or unserviceable automobile or machinery parts, used or non-functional furniture or appliances, or, and this is the key, used and non-functional tools, equipment, and implements, but shall not include compost piles for normal, personal, or commercial use. Then it goes into debris. Debris shall mean material which is stored externally, exposed to the elements, and is not otherwise completely enclosed by a walled roofed structure, and shall include but is not limited to the following: discarded household items, inoperative machinery, appliances, refuse, rubbish, trash, or junk, scrap or discarded lumber, pipe, steel, plastic, glass, paper, cardboard, plumbing fixtures, and other building material. Now, I don't think all tools fall into that, and I think you said the garden tools don't.
Yeah.
A dolly that's just there, I don't think falls into that
Okay.
definition.
What about a
Yeah.
grill?
Yeah, if it's discarded or unused, but what's your perspective?
A grill is not part of this case, and I've never put grills as part of junk as long as they're usable. If they're in pieces and obviously can't be used, then that would be junk.
Okay.
My
So
dolly's
what do
not in
you, what
pieces.
do you believe qualifies under this?
Okay, so for this case, he's got dog kennels that are folded up, not being used, leaning outside. He's got cardboard. He's got like fabric. I don't know what it is, if it's sheets or clothing or something. It's some type of cloth material out there.
Plant coverings over winter.
He's also got, the tree debris is really the major issue. And then he's got cinder blocks just discarded throughout the yard. That also needs to be picked up.
I think the vegetative matter is probably the biggest one.
Yes.
Yeah.
Yeah, you're not, the cinder blocks.
I just don't want to
mean,
muddy the waters, and I don't know what cinder blocks she's talking about. I have cinder blocks that's.
But it won't matter. I mean, if there's no cinder blocks that are just lying around. Let me see. Where are the cinder blocks? You're not aware of cinder blocks?
Is she referring to the back?
Yeah.
Okay, because we just spent an hour talking about the right of way. That's why I'm like, what? So for the cinder blocks in the back, I'm using that as a partition to protect baby plants as they start, because I'm also a dog owner.
It's not
So-
being used that way right now.
And you know, there. Can I see? I guess which photo?
I'm kind of done with this hearing. I really have to get to the other people.
Okay, just-
I will be specific in the order and
Yeah.
give you the guidance you need, and if you disagree with it, you can
Yeah.
appeal.
Okay.
I conclude, oh, so that's gonna be the, I think I've given the fine on the
Yes.
junk
Yes.
case. We're good on, I'm gonna issue the order in the April hearing, so you can feel free to attend on that. Is there anything else?
No, Your Honor.
Thank you.
All right,
Thank
we're
you.
good?
Thank you.
All right. Cool.
Next case on the day's agenda, Hubs Ranch and Grove LLC, case number 2024-620. Code officer on the case will be J.C. Charlton. Page 13 of your agenda. Experts on the case, Samuel Costa and Joanna Katu.
Good morning.
Hey, good morning.
Good morning.
Morning, sir.
Do you swear
I'm
to
sorry.
tell- Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
So my recollection of this was that it was by a I mean, this was the one we entered by agreement, correct?
Yes, sir.
Some of it.
Okay.
Entered by agreement on the use, you issued the subsequent
I know,
order
that
as
one,
to
I took my time on it.
the
yeah.
actual structures themselves. And this is as to the actual structures themselves, not the use portion that we're having.
This is the after use. It was case number 620, 2024-620.
All right, well then help me, where are we at on this?
This is.
Yeah, what's going on? I mean,
this
why
is-
are we here?
This is a fine appeal.
Okay. So is the property in compliance?
No.
What's going on? Just, I want to know, yeah.
I think this is a mixture of unfortunate circumstances. When we did come to the agreement, you had mentioned you wanted to give us as much time to make sure we could get in compliance. To be frank, that was about a week and a half before the first of the two hurricanes hit. I don't know what happened up here, but all of the owners of Hubs Ranch and myself included are all in Pinellas County. And their initial business is a marina, which got 5 feet of water in it. Then we were hit by Milton, and effectively Tampa Bay was shut down for about, what I would say about 30 to 60 days of that
Yeah, I
time.
mean, all these counties were under a declaration of emergency from the governor.
And all of that being the case, my clients have gotten what they believed was under your order, which specifically stated, sorry, I want to make sure I'm quoting it correctly. Sorry, that's the order imposing fine. Which said that obtaining permits to electrical work, additional solar panels, added buildings, including screened enclosures, re-roofing, heating, and air conditioning. pulled 7 permits, all under agriculture. I think that the actual notice that got sent to you for fine was due to a miscommunication and unfortunate circumstances and reasonable misunderstanding of interdepartment communications. My clients have been working with permitting, got the approval for all 7 of those, said, is there anything else we need to do? Thinking that that was finalizing things. Officer Norman showed up on the 23rd saying we never notified them. One of my clients was in Spain with her family for Christmas, and the other one was multiple hours away, said we couldn't meet. I actually contacted the head of the department. We tried to start working on getting the time, and ultimately we had what I would call a gaggle of folks out to explore the property. They took pictures. There's 3 things that are still not in compliance. I'm not saying we shouldn't be getting those in compliance. I just don't think that the 3 fall under your original order.
Okay. What remains to be brought under, well, if you're saying it doesn't fall under the order, then does it need to be brought in compliance?
I believe that if you'll recall during our first hearing, I was really concerned about there being after the fact findings.
Oh, you mean things that are discovered afterwards?
I can bring you the finding of fact and conclusion.
Well, let me
of
ask you,
law.
I mean, have you heard anything you disagree with?
Yes.
Okay.
Yes. Yes.
Well, that's important then. So y'all aren't really necessarily in agreement on the scope of what should have been brought into compliance by now?
Correct.
Under my order?
Yes, sir.
All right. Yeah, then maybe looking at the order would be a good place to start.
Okay.
If you have a copy.
Yes, I do. I'll go ahead and just list the evidence that I have.
Well,
Exhibit
it's their
A-
appeal. It's
Okay,
their
okay,
appeal.
okay. All right.
Somebody else have an extra copy of the order? Give him a copy of the order
Okay.
so I can read one. He needs to see it though.
I'll give you
It's
mine.
just, I mean, so
wanna
basically
look
the
at it real
way,
quick.
the way I look at this is that there's an appeal here, so I need to hear, number 1, what's my order, but number 2, what's the basis for getting out of whatever the consequences are. So I have a copy of my findings of fact conclusions. Let me just take a look at it. I mean, I certainly didn't foresee 2 hurricanes coming in that time.
I don't think any of us did.
You know, in Florida statutes, we have a law that says development orders automatically get extended by 6 months upon the declaration of an emergency. I don't think this is a development order, but that's the kind of thing that is normally considered. Let me take a look. All right, so has the electrical work been permitted and completed?
All electric, I don't want to speak
you know
out of turn. To what I know of, is all electrical that was required was permitted under the agriculture permits. And if I can submit, these are what we were told by, after our walking around.
Can I,
If you would show them to the county.
Yes, and these are the same ones that, yeah, also, if you want to do it. That's closer up, that's nice.
so, and it might actually make it a little bit easier when we went out and looked, because the attorneys actually went out and did the walkthrough of the.
You went?
I did, and
Okay.
Mr. Alonso did as
Okay.
well. We actually broke it down by each piece on the property, like the barn, this barn, different.
I see.
Versus looking at it as electrical, and that way we did
Yep.
it by each
I got
piece
you.
on the property.
I got you.
And I don't know who's going to give him photos.
Do you want?
I don't know what you guys want to show me, to be
Yeah,
honest.
okay.
This is Mr. Lonzo's appeal, so I want him to kind of marshal the
Okay.
evidence.
Want me to move it to him, or you want to do it? Okay.
Honestly,
Thank you.
I don't think, I will tell you, my clients are sick of me saying this. This is not about fighting. We're trying to get in compliance. It's just been trying to get in compliance. There were unnecessary delays due to the hurricanes, due to the time we were, it was over the holiday break when we were making.
I think that's actually a necessary delay. So what am I looking at? I've got 3 photos.
Those were, so after our walkthrough, we asked for a report of what still needs to be done. This was the 3 remaining items that were given to us.
Okay.
And that, I believe, the first one you're looking at is a gazebo, 2-story, yep. The only electrical there is a solar panel, it's a portable solar panel. The second one.
A portable solar panel
Yes.
remains to be done?
Do we still have the portable solar panel?
It's still there. There was no issue with it being.
Yeah, I gotta swear you in if,
Sorry.
do you know, or do you want him to testify?
I know that it is there.
Oh, but you're saying there's a portable solar panel?
Yeah, it's a portable solar device that
And it just
provides-
hasn't,
It's attached to the gazebo.
okay.
And it
That's
would
it,
fall
yeah.
under the permit that they have applied for.
That's what I
for
wanted
the
to know.
gazebo.
Okay.
Right.
Yeah, and then the secondary one, I believe, can you show me which one you're looking at?
It's the dock.
The dock?
The dock, it's, at high tide, a dock, at low tide, a platform over dry land. And then the third one is the structures that the glamping tents sit on top of.
Okay. These are the 3 remaining issues.
Those are the 3 remaining issues, but they're all structural, which, again, our understanding of your order.
Well, wait, what's structural about the gazebo? The gazebo itself hasn't been?
Correct.
I see.
Yeah, and all 3 of those we're in the process of, we have architecture that are bidding out and being able to get us what we need. Honestly, it's just we ran out of time, and the idea of a $500 a day fine, knowing that we had 60 days lost from the hurricanes, and then also 2 weeks lost because of travel over the holidays. We're just looking for an extension of time to be able
What
to
does
get
the
this
county
done.
disagree with?
Then we tried to conduct a compliance inspection from your order on the 23rd. We was not allowed access to the property to conduct an inspection, and then prior to going out to that inspection, we checked for permits for everything that's required a permit under that code section, and we didn't find permits for those 3 remaining items.
Did you have evidence of other permits applied for and/or received?
They were in review, but I wasn't aware that they had been approved yet.
As of December 23rd?
Correct.
How were you denied access?
Code Officer Brandon Norman, he went to conduct the compliance inspection based on from what was told at the hearing that we would, be able to get access to the property, and he was denied access.
Did y'all try to contact Mr. Lonzo?
I don't know if he spoke with Mr. Lonzo. I know he did speak with property owners.
Okay.
The call went to the property owner. I was informed via the property owner that they were looking to get on. And again, my property owners were either in Spain or multiple hours away because it was 2 days before Christmas.
So why were they denied access?
Because my property owners want to be there. We've been asking to have the conversations, and as I said, I immediately made the call to the department to try and schedule
Well,
something.
there's no mystery about what it would have shown regardless, right? I mean, I don't think there's a dispute that what an inspection would have shown. Okay. Was anything fixed by the December 23rd?
Not that I'm aware of. I wasn't aware that the agricultural buildings were approved at that time. From our inspection that was conducted on January 10th, that we were allowed access, we were able to match the approved agriculture buildings and actually get access to the property to see what buildings, where they were on the property. And it still failed their inspection due to the remaining 3 items not being in compliance, having permits.
I mean, what percentage would you represent has been done pursuant to the order?
Maybe 70%.
Okay.
Yeah.
And this is just, you were mentioning that you weren't aware of, I have an email chain where we got informed by Suniva Brown that the sign-off for recognition of the 7 farm shelters was approved on December 5th.
Okay. How long is it gonna take to bring what's left into compliance?
Can I confer with my clients? real
Yeah,
quick?
please.
Could I just ask one clarifying question for my own, because in Pinellas County, like 6 months behind on permitting. What's the range, once we get it submitted, do we have an expectation on how long that would take?
That have been, for these?
One submitted and not all submitted and incomplete, no attachments.
Ms. Katsuri, do you want to say that into the,
Do you want to?
It'd be helpful, yeah.
into the mic, please?
I'm sorry, so we do have 2 permit applications to cover the items that are still outstanding. One has been submitted and denied, lacking a lot of information as far as engineering and stormwater, et cetera. Another one is submitted with no attachments whatsoever, so it hasn't moved forward. So we don't have complete application yet on that one, so on one
Well,
of them we do.
I mean, what they're asking is, let's assume all that to be true.
Right.
Let's assume they get it all in tomorrow. How long would it take?
You have a guess on non-res?
We typically get review comments out on something like that within a couple of weeks. And then it requires action.
And it may require
action on their
revision,
part.
yeah.
Then-
Okay.
So my understanding from my clients is we have 2 folks that we're bidding out to be able to basically retroactively provide what we need from the engineering and stormwater to be able to submit the permits.
Okay.
We're in the process of getting those bids. As soon as we get them, we intend to submit, and then it's at the will of how long it takes to get it done and pass the provision.
All right, so what do you want me to do exactly?
I would ask that we have an extension for 90 days to be able to get everything submitted and approved, and postpone what the fine was, or the accruing time of the fine. While I agree we did deny access, I think that was more of a misunderstanding rather than we thought we had communicated through somebody, and then
I don't think it was a misunderstanding. I mean, I understand the concerns. It also seems to be a pattern, but it also wouldn't have changed anything. So I don't really.
I don't disagree that we were out.
Yeah.
Again, my argument at first is your order specifically says buildings. I don't know if I would call those buildings. One of them is literally a platform, so I don't know if that would have been, as you recall, we spent many hours talking about the glamping tents, but I don't recall that actually being something that was covered in
I
this
construe that
aspect.
as improvements as well, but I do see your point.
The
Okay.
dock as well.
Yeah, yeah.
So,
Well, it says any added buildings, including any screened enclosures.
which did specifically address one of the barn buildings that we got addressed.
Right, but I think it goes to show it's not like it's a traditional building. Well, what is the county, does the county object to this request? I don't know who to look to. Does the county object to this?
At this point, the county would object to the request. We've had the final order. The final order has been issued, and the time to appeal the final order has run. So his request is not for a fine appeal, but rather for an amendment of your honor's final order, for which the time to appeal has already run.
That's true.
So based on solely what the purpose of this hearing was for, this is a fine appeal. That is not what we're here for today, so we would object to the request.
Now, based on the compliance, I have no reason to think that it's not 70% compliance. Let's say 70% at least. I am allowed to take that into account to determine whether a fine should be overturned or reduced, I believe. Am I not correct about that?
Yes, that is information that your honor can take into
So
account.
the thing is in a fine appeal, I don't know that I have authority to extend a deadline. I don't know.
Understood.
I've never done that. My understanding of what I can do is, based on the representations and findings made at a hearing, I can reduce and eliminate based on compliance. So I think what I would be willing to do is, based on the representations regarding the hurricane, plural, that I would eliminate the fine for a period of 30 days and reduce the fine from that date forward in half. In other words, I think 500 would be excessive based on the amount of compliance that has occurred. I think it would be punitive. That was made in light of the agreement of the parties, the amount, and the belief that all of that could have been done. There's no reason to believe that we could have, I mean, I have every reason to believe that hurricanes would affect that. So I think this fine, when did it start accruing? December
23rd.
23rd, so,
So you would be reducing it from 500 to 0 for December 23rd through 30 days? And
Correct.
then reducing it to 250 beginning, that's 30 days after that.
and even that, I mean, I'm struggling with it, because it sounds like there are substantial efforts. The whole point is compliance. It's really very rare that the situation happens where there's this much compliance and,
We're trying our hardest, and I'll be honest, we needed the meeting we had, and I wish we would have done it. I will take responsibility for that, for not reaching out to code enforcement earlier to have them out. We needed the meeting we had to know where we still had problems, and, you know, like I said, we were all there. The intent was to get us there. And to your statement of 30 days, I would say that we, down in Pinellas, were at least impacted for,
well, you might want to look into whether or not this qualifies as a development order that automatically gets extended for 6 months. I don't know the rule.
Understood.
I know I've had to extend PUD development orders in other cities based on this, but yeah, look, based on my authority, what I'll do is I'll eliminate the fine from the 23rd to today, and I'll reduce it in half from today going forward. That's all that I think I can do, to be honest. I encourage y'all to get it fixed, and if there's another fine, you might seek an appeal at that time, but that's what I'm willing to do.
understood, I appreciate it.
Okay,
Thank you.
Thanks.
Thank you,
sir.
Your Honor.
Now, I would like to ask all the people, oh, by the way, is there anyone from the public who wants to be heard on that case? Because I skipped that. All right. Now what I'd like to know is, are there any persons here who are willing to admit that there is a violation on their property? Because if you are, I will get you out of here and we'll go through the process. So by show of hands,
Okay.
all right, let's go. I'll let you pick,
Okay.
but this is what we're gonna do.
Thank you. Next case is Mildred Gore and Charlotte Morissette, case number 2024-2146 and 2024-2147, pages 9 and 10 of your agenda. Excuse me. And case number 2024-2148, page 11. Expert on the case, Joanna Katu.
Ma'am,
Oh, I'm
do
sorry.
you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Can you please state your name?
My name's Mildred Gore
Thank
Cleveland.
And is Miss Gore Cleveland? All right. This is how I'd like this to go. So what I'm doing is I'm asking people who are ready to just admit there's a code violation and to proceed to me giving you a time to bring the property into compliance. Does that make sense?
Yes, sir.
All right. Are you willing to concede that there is a violation in each of the 3 cases that have been described?
Yes.
What is the county's recommendation, first of all? And we'll get to the time, but no, I'm sorry.
We've done a lot of cleaning up.
Well,
I can't go out there and do it myself. I have to get somebody to come in and help me
and
do
so
it.
that's what I want to get to. How much time do you think you need?
Probably about another 2-3 months.
And Your Honor, I need to clarify something. Ms. Gore has a 4th separate case before citation with the county court. So this isn't, when she says clean up, I don't want her to think this has something to do with the case she had with Judge Spate this past week. This is.
I don't even know what I was there for the other day when I was in court. I know it was something to do with.
That's okay. I'm going to proceed, and what we're going to do is I just want to know how much time you need to bring the property into compliance. You've said 2 to 3 months.
About 3 months, yes, sir, because there's a lot of stuff in the back.
I do see, I'd like to see the photos. Can you stipulate, I want you to look at the photos real quick. And let me know if they're accurate, because that's how I'll know how
What
much
is-
time
oh.
to give you.
I don't even know what I'm going, oh, this is that's the trailer, right?
Yes, ma'am.
Okay.
That's since been removed.
What is this?
That's the car that was in the back. It's next to the
Oh.
Ford pickup.
No, yeah, that belonged to my brother.
Yeah.
He passed away. I just had it for my brother that had nothing else to do with it. Okay. Yeah, we got rid of both of those back there.
No license plates.
Oh, I'm sorry. This, we got rid of the boat. My son's working on fixing his boat. And the cans, we got rid of all of those. I'm a nervous wreck. Before 9 o'clock. What is this? This is what the hurricane did. That's just trees.
That was a photo of all of it in one.
Who was that? What do you mean? Off my porch. I didn't have none of the back of it that cleared out because I didn't want it cleared out. When I moved in there, okay, this here and this one here, you said they could stay, right? You still here? Because we got stuff stored in them because of the hurricane.
This
And-
is for the unlicensed vehicles.
Okay, and this is built into what they call a tiny house?
Ms. Gore, what's up? What do you want to know?
I think she has questions about the specific.
My brother-in-law passed away, and he gave me the thing that's built in the back. It's a tiny house. It's built, they bought a shed and made it into a tiny house for him and his wife.
Case, ma'am.
Huh?
That's a different case.
That's a different case. Never mind, that's a different case. That's like I say, I'm not sure what,
Here's what we're here for, and I'm gonna just make a ruling or ask to reset this hearing. This is only for people who are ready and able to tell me. So this is for the overgrown grass, if there's overgrown gas,
Yes, sir.
Okay, and for inoperable unlicensed vehicles.
yes, sir,
okay?
we've got rid of some of them, but
And
we're
for
still working.
temporary occupancy of a recreational vehicle,
Yes, sir,
which
they was staying in there because
I don't need to know why. I need to know how much time you need to fix it. 3 months?
about 3 months should work.
Okay,
Yes, sir.
let me just take a look at the photos, and if you would.
I don't know, do you have any of what we've got done so far?
Oh, wow.
It's in there.
I had so much of the land cleared because I was only putting a trailer on it. I've been there like 24 years.
You gotta get
25
some,
years.
you really ought to get some value for those cans and get them to a recycling
I
place.
throwed them all
that'll-
away. He told me I
Okay.
had to get rid of them, so I just throw them away.
All right, Mr. McGuire, do you have any concerns, like immediate health, safety, sanitary concerns that would require this to be fixed faster than 3 months? I mean, be honest, I mean,
Yes.
okay, what are they?
The conditions of the RV and the shed being occupied.
Every time I try to
It-
accelerate this, it's, I'm foiled. So, all right, well, then, what, is this an immediate health, safety, sanitary concern?
Well, environmental health's already been out there.
Okay,
As far as their findings, I'm not sure.
okay. I mean, do they have the power to compel this to be fixed as well, or to remove people from the property if there's a health, safety, sanitary concern?
That would be great.
No, do they have the authority?
Oh,
Do you
I'm
know?
not sure.
Is this not appropriate for a summary disposition then?
I was out at the property with Officer McGuire, and the septic hose, and this is why we turned it over to environmental, it's going straight in the ground. So that's the environmental aspect of it.
So that, but that would only apply to the temporary occupancy,
Yes, sir.
correct?
Yeah.
Okay. So Ms. Gore, here's what I'm inclined to do. I would be inclined to give you 3 months to solve 2 of these cases. On the temporary occupancy of an RV, this is dangerous potentially. I cannot give you 3, I
Okay.
can't even give you 2 months to do that. I would give you 7 days.
Okay.
Now, I'm not going to do that. We can proceed through the whole hearing, and you can give me a defense if you want. But the problem is that's where you might be affecting other people's health by what it sounds like the hose going into the ground without proper sewage disposal.
Honestly, sir, I haven't met there. I didn't know there was a hole going in the ground, but I will take care of it when I do get home today.
Okay, what's the county's recommendation on fine?
$100 per day.
I'm going to find a violation in each of these 3 cases, Ms. Gore. On your overgrown grass case and the junk case, it'll be $100 a day if it's not brought in compliance within 3 months. That should be more than enough time based on what I saw.
I gotta pay $100 a day?
If you don't bring it into compliance in 3 months,
Oh,
okay? So that's enough time, okay?
yeah,
But I'm only giving 7 days on the RV case,
okay,
okay?
all right,
And if it's not brought in compliance, it'll be $100 a day there.
okay.
Are there any members of the public who want to speak about this case? All right. Well, that was record time. Thank you, Ms. Gore.
Thank you.
Appreciate it.
Thank you.
Good luck.
Next case, Equity Trust Company, case number 2024-2166. Code Officer Julie Wilkinson, page 6 of your agenda.
Good morning.
Good morning.
I already. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your name, please, sir?
Timothy Hearn.
Thank you.
Sir, are you a representative or owner of Equity Trust Company?
No, well, indirectly, it's a property owned in my custodial account, so Equity Trust is the custodian,
Yeah.
and so it's FBO for benefit of me.
Makes sense. Are you conceding that there's a violation on the property?
I'm pretty certain there was a violation. We've had some work done, and I would like to get maybe a little bit more direction from Ms. Wilkinson as to what maybe.
This is only for cases where people are conceding that there is a violation. I want to be clear, because I want to get those people out.
Yeah, no,
It sounds like
I-
you don't qualify.
Yeah, no, I'll agree there was a
All right,
violation.
how much time do you need to, well, actually, let me ask you this, sir. How much time do you need to, if there remains a violation, how much time would you need to fix it?
If they're requiring that I have to remove all kinds of tree debris and stuff, then it could be up to 3 or 4 months, but the major part of things have been done in terms of
Do you
vegetative
think,
matter.
Ms. Wilkinson, just off the top of your head, do you think 3 months is how much time it might take? How big is this property?
It's
The
5
property is 4.84 acres. It's pretty sizable.
Can I see the photos?
Yes, sir.
Do you stipulate to letting me see these? Yeah.
I-
Okay,
yeah.
you're gonna trust me? Big mistake, man. All right, let me take a look at this. It's a nice piece of property.
We had about 3 or 4 trees that came down as a result of the hurricane.
Yeah,
Yeah.
th-
And
this
I don't
looks
know-
like
I don't know if you've
hurricane.
been out there since, but we've had a contractor out there taking care of some things.
Yeah, I saw some improvement,
okay,
yes.
Okay.
Someone complained about this?
Yes.
Wow, okay.
Yeah, we.
Well, what's the county's recommendation on a fine?
$100 a day.
You have 4 months. If it's not brought into compliance in 4 months, $100 a day.
Okay.
Thank
Agree-
you.
Thank you.
Agreed. Thank you.
I'm sorry, are there members of the public who want to be heard on this? Okay, thanks. The tree's in the middle of a 5-acre yard. All right, good luck. Good luck.
Next case, Soldier Boy Properties, Inc., case number 2024-02156. Code Officer Alan Jonason, page 28 of your agenda.
Good morning, Your Honor.
Are you the Soldier Boy?
I'm not the Soldier Boy,
Oh, okay.
but I am Mark Scott. I'm the registered agent for Soldier Boy Properties.
Very good.
1 second. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Yes, ma'am.
Can you repeat your name, sir? I didn't-
Mark Scott,
Thank you.
M-A-R-K-S-C-O-T-T.
Mr. Scott, are you conceding whether or not there's a violation on this property?
There is a violation on the property.
How much time do you need to,
Whatever we need is 30 days tops.
do you have any reason why 30 days wouldn't, what's the county's
It can be
recommendation on a
done
fine?
today.
What's the issue? I called on Friday, but.
I called you back, it went straight to a dial tone every time I called you.
Really?
Yes, sir.
Weird.
So, what's the recommended fine?
$100.
All right, I'm gonna grant 30 days and $100 fine if it's not brought into compliance in 30 days.
Yes, sir.
Okay, thank you very much.
You bet.
You can actually send the photos if you want, so
Yep.
you can see what it is.
I'm sorry, is there anyone from the public who wants to be heard on this case? All right, I don't see any. Next case.
Do we have a show of hands who else was not contesting?
Yeah, we're just gonna take the folks who aren't contesting.
Or, yeah. Smith. Next three cases, Ralph W. Smith, case numbers 2024-2108, 2024-2115, and 2024-2116. Code Officer Erica Olson, pages 25, 26, and 27 of your agenda.
All right, thank you.
Raise your right hand, Ralph. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Yes, ma'am.
David.
And what are y'all's names?
My name is Ralph Smith. My sister here from Ohio, Wanda.
Wanda Evans.
Very good, okay.
Thank you.
So we're here on three cases. One of them is, well, these are all, all right, so we've got an unlicensed and inoperable junk case, and then two, what I call LDC cases. One has to do with special requirements for an accessory use. Sounds like there might be some kind of truck, vehicle, trailer issue on this property. Go ahead.
Yes.
Yes,
So,
I am in no dispute about the violations.
Okay.
I'm just here to ask for an extension,
Yeah, how much time do you need to bring them into compliance?
60 days.
Okay, is there any immediate health, safety, sanitary concern on these cases?
Nothing.
Is
no.
and I'll be asking the county this, does the county have an objection to 60 days?
I don't. I will say that Mr. Smith has told me that he has renters on the property, and that would be my only concern.
Meaning that it might take more time?
Correct.
Well, I actually think an owner has the right to go and fix things on their property. I know that sounds crazy. What is the county's recommendation if it's not brought into compliance?
We recommend a fine of $50 per day per violation, along with administrative costs to begin after the date you deem sufficient to abate this violation.
That's as low as the county goes. Is there anyone from the public who wants to be heard on this case? Sir, please.
do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Your name, please?
Edward Borland. Now, we rent the property, so I'd just like to see the violation so we can remedy the entire situation. I did a ton of work the other day. I got a privacy fence up. I'm trying to get everything done. There's products getting sold off the property that just gotta go. But you can't take a total bath on everything that you've invested in over the last 10 years.
Well,
So that's what we're trying to do. We'll definitely have it done within the 60
Okay.
days, but I just want to be able to speak with her.
I'm going to issue an order, and I'm going to explain what the violation is, all right? And I encourage y'all to stay in touch with Ms. Olson and just make sure that as you think things are being brought into compliance, she can come out and check, okay?
Right. Well, that's all, most
Yeah.
of it's going to be done by this weekend, so I'm not really that worried about it, but.
Thank you. Is there
I
anyone?
work full-time job too, so it's like
Oh,
work plus do that.
I hear you. Is there anyone else from the public who wants to be heard on these cases? There's three of them. All right. Sir, is that it?
That's it.
Thank you very much. I'm going to find that a violation has occurred in each of the three cases. I'll grant 60 days to abate each of them. To the extent not abated in that time, there would be a $50 a day fine. Okay? Thank you very much.
Thank you.
Next two cases, David Fiera, case number 2024-2081, and David Fiera and Betsy Cruson, case number 2024-2082, Code Officer Julie Wilkinson. They're two different properties, is that, do you want to run them
It's
together, or?
y'all's policy. Why don't we do them separately?
Okay,
Yeah.
that's fine. First case will be David Fiera, 2024-2081, Code Officer Julie Wilkinson, page 7 of your agenda.
All right. Mr. Ferrera, you've been sworn in?
No.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir.
Now, Mr. Ferrera, we've met before.
Yes.
Is this a first time, or, I mean, what?
For this particular, the
Okay,
last time we
gotcha.
were having a dispute over signage
Yes,
and
that's right.
advertising.
All right. Are you conceding whether there's a violation on this first case that we're
There is a violation. I'd like 30 seconds to explain the violation. Since the hurricane.
Don't really want to know. I mean, here's what I want to know is.
We have met and fixed all of the problems. I have pictures of everything.
Well, no, here's the thing. What I'm doing, everyone here has a right to be heard.
Yeah.
You know, and I want you to exercise that right if you want it. I'll take the time, okay? But what I'm trying to do is get the people out who are ready to come in from the cold, so to speak. They know their property is in violation. They tell me how much time they need. We agree, you get out, all right? So how much time do you need to fix this violation?
It has been completed, and I have proof of it here.
Okay, so you're saying in the, Ms. Wilkinson, have you gone out? Did you go out yesterday?
I went out on Monday.
Monday?
Yes, sir.
And was there still a violation at that time?
Yes.
All right, Mr. Ferrer, would you show your photos to Ms. Wilkinson?
This is in front of the building between them. This is down the sidewalk that has been cleared and put back into order. That's the front of the store. This is the side parking lot where there's nothing left under the camper, underneath the trucks. Everything is registered and otherwise usable, and this is the front of the building.
Okay.
There is no longer any trash. We've made our final run.
Hold on, Mr. Ferrer. Let's give Ms. Wilkinson a chance to look at these.
I am just kind of, there's one particular area that is missing from these photos,
Okay.
which is where they have the trailers that they store all the junk in the parking lot that's not being shown in these.
Mr. Ferrer, let's assume that that is still in violation.
I'm trying to find out what's.
Hold on. Let's assume this is my problem.
Yeah.
This part
My
of the
problem
hearing
is this
was
is a
only,
never-ending
I'm not
story.
done. This
Yeah.
part of the hearing was for people who are just ready to, ask for how much time they need. I don't want people jumping in line with a case that's not one of those things. So, how much, let's assume that what Ms. Wilkinson says is right. There's been a lot of improvement. It's almost there. There's one area that there's no proof of.
I don't know what that is.
How much time would you need? What is it, Ms. Wilkinson?
It's the trailer that's full of junk or donations that they have that.
There are no trailers full of junk. Zero.
Well,
Not a
there's
single one.
on
There is
one
one
of the.
that
All right,
leaves
we're
every
taking
single
this up
day.
next. We're not
Okay.
doing this hearing. Thank you, Mr. Ferrer. If you would go back to your seat. Thank you. This is for cases where we're going to be able to find an agreement as to the violation, and
Do we have anybody else that
if there's no one else,
does not
that's
wanna
fine.
contest?
Okay. There's a bunch of people.
Next two cases on the agenda, Carvis Wolf, case number 2024-2206 and 2025-010, Code Officer Alan Jonason, page 30 and 31 of your agenda.
Good morning.
Good morning.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, sir.
And are you Mr. Wolf?
Yes, sir.
Okay. And are you conceding that there are, I guess, there's two different properties here. One is 6573, I guess they're probably adjacent lots. Is that right?
Yes, sir.
And are you conceding that there's a violation on each lot?
Yes, sir.
Okay.
Yes,
And
sir.
have you had a conversation with Mr. Jonason
I
about
haven't personally
Okay.
spoke with him on this thing of, I had a previous violation that I took care of, and then this one was again the same situation of, which is a violation of, I had some trailers parked on a lot that's deeded, it's supposed to be an empty lot, of I have took steps to, I moved the trailers off, I've cleaned up the junk, there's a little bit of junk left. I've also went up to the office here and got a merger of the property, which I had notarized, and they said that I needed to record it. I also recorded it with the clerk of courts annex.
Okay.
And I'm supposed to turn that back in while I'm here today.
Okay, well.
On that aspect.
All right. Now, so Mr. Jonason, this isn't a repeat violation.
It is a repeat.
It is a repeat.
Both are repeats, yes, sir.
What's your recommendation?
So I'll do the junk case first.
Okay.
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day
along with the administrative cost to begin on the date of the posting of the property, which was 7 January 2025, and continue until 18 February 2025. That would be 43 days at $100 per day, totaling $4,300, and a fine of $200 per day from this day forward until the violation is abated. We would also ask that the special master additionally find that it is the respondent's responsibility to notify the Code Compliance Division when the violation has been abated in order to allow for reinspection. Same goes for the storage case.
It's the same amount
Same
and
amount.
the same time
Same
period?
total, 4,300, yes.
Well, all right, so how long is it gonna take you, by the way, do you think, to fix these violations?
I believe I'm within striking distance of even today, of as soon as I get home. I just asked for mercy on the legal fine. I'm not a rich man. I work every day. You know, I've been trying. I don't get many days off because I'm a lead guy out at my job, to be able to do the paperwork to combine my properties. I just, like I said, I just plead for mercy on the fines because of, you know, that would detriment me. I mean, it really would.
Mr. Jonathan?
The storage case was abated yesterday on 6569. It was abated yesterday.
I don't think I have that. That's not in front of me, right?
Yes, sir. 2025-00010.
Oh, 00010. Okay,
Yes,
so
sir.
there's no fine going forward on that.
After today, no. Previous, yes.
Right.
From the date of posting.
Right.
Yes,
okay.
sir. The junk is still
So,
there. on
right,
the-
junk is
Yes, sir.
still in progress. But you're saying that the storage case abated yesterday?
Yes, sir.
Okay, so I would not be finding a fine for today.
After today, there will be no fine.
Why would there be a fine today if it abated
There-
yesterday?
Because there is a fine from the date of posting the property up until the day it abates.
For it being a repeat,
Because it's a repeat.
the store.
I thought it abated yesterday.
It did. So the fine starts on the day we post the property. It ends when it abates.
So going forward, there won't be a fine.
He's just saying it's not today.
Yeah, that's what I mean.
Oh,
I'm not
I'm
gonna
sorry.
find a
I
fine.
misunderstood you.
Okay, okay, all
I
right.
misunderstood you.
All right, so, in case number 25-10, which is the case that abated, I will find that there was a repeat violation, and assess a fine of, $50 a day instead of $100 a day, which is really the lowest that we do,
I
because it
understand,
abated, okay? So that abated. So for 43 days, I think that ends up being, what, $21.75, something like that. But on case number 24-2206, I'm going to follow the county's recommendation on the, well, what I'll do is I'll go down to $50 a day for the repeat violation. So 43 days at $50 a day, but I will agree with the county that it should be $200 a day from today's date going forward to make sure that it gets done as fast as possible. We have to deal with repeat violations that way.
I understand. Is there any ways that I can get an inspection maybe this afternoon and I can go home and take care of it so there is no?
I would work that out with the county. That's not my purview. I know that they do try to solve these as fast as possible.
Okay.
Is there anyone from the public who wants to be heard on this case, or either case? All right, thank you, Mr. Parvis. Good luck.
Thank you. Thank you.
Next two cases, William B. Portwood, case number 2024-2056 and 2024-2057. Code Officer Jillian Nocella, pages 23 and 24 of your agenda.
Good morning.
Hello. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes. Thank you. Can you please state your name, ma'am?
Christine Portwood, I'm William's wife.
Okay. And are you representing that you concede that there's a violation on the property or two violations?
Yes, and they've actually been taken care of. I wasn't able to talk to Jillian yesterday to figure out what was going on, so I figured I'd show up in person to make sure everything's taken care of and
Okay.
copacetic.
Were you able to take photos yesterday or go out there?
I did, when I did my inspection yesterday, there was still a violation.
Okay.
We spoke prior to being called up here, and seems like we have it worked out and have a plan for me to re-inspect this
Okay.
week, so.
Is 7 days enough, given that you?
Absolutely,
Okay.
yeah.
What's the fine if it's not brought into compliance?
$50 per day per
All right,
violation.
so on each is there anyone from the public who wants to be heard on these cases? All right, Ms. Portwood, in each case, I'm going to grant 7 days to bring the property into compliance. If it's not brought into compliance as ordered, $50 a day.
Cool,
Good
thank
luck.
you.
Thank you.
Okay.
Next two cases, K.M. Martin, case numbers 2024-2042 and 2024-2043, pages 16 and 17 of your agenda.
Yes, ma'am.
She's already been sworn in. And I thought it was Paige.
Yes, sir.
Kay?
No, sir, I'm Paige.
No, I mean, it says that
Kay is
the
my
owner is
mother.
listed as Kay.
Kay is my mother, Kay and trustee.
Okay, so you're not an owner of the property?
No, sir.
Okay, all right.
This is also a repeat violation. If you'd like, I can just give the,
Well, first
the
I want to
total.
know, I guess,
Yes, sir.
Ms. Martin, are you conceding that there are violations
Yes,
on the
sir.
property?
Yes, sir.
Okay. And are you conceding that this is a repeat
Yes, sir.
violation? All
Yes,
right,
sir.
then please tell me about it, Mr.
Yes,
Johnson.
sir. The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative cost to begin on the date of the posting of the property, which was 23 January 2025, and continue until 18 February 2025. That would be 27 days at $100 per day, totaling $2,700, and a fine of $200 per day from this day forward until the violation has been abated. We would also ask the special master find that it is the respondent's responsibility to notify the Code Compliance Division when the violation has been abated in order to allow for reinspection. And that is for both violations, same amount.
Ms. Martin, my inclination is to do what I did on the last case. It'd be one thing if it was just one case, but there's two, so it's gonna end up being, I think, the same fine situation. So what I'm inclined to do is to cut the repeat fine from $100 a day to $50 a day, but then do $200 going forward. The problem, this is a deterrent thing, you know, neighbors can't keep dealing with it.
I understand.
But you indicated earlier that I thought you indicated you wanted guidance, or in your comment, in public comment. So is there
No.
any confusion about?
No,
Okay.
I don't do well publicly.
No, that's okay.
So
You've done
probably,
fine.
I probably misspoke.
No, you've done fine.
I'd
Okay.
like to see pictures, and then I have somebody, just so that I visualize, because I haven't been able to be up there when Mr. Allen has been there. So I don't, we have somebody on the property now. We were supposed to meet up over the weekend, but a family member's gone into hospice, so we didn't start till yesterday. So I just have pictures of what was done yesterday.
Okay.
They're working today and tomorrow to clear the land, the vegetation, which I'd like to submit that. The other stuff, I will take a little bit more time, but this gentleman can continue to help me. I just hadn't been able to find him until recently.
Well, you know, on a regular case
Yes.
where it's not a repeat violation, it really becomes relevant for, like, the photos become relevant, because it's like, okay, how much time do you need to fix
Yes.
it? On this, because it's a repeat, it
Yeah.
actually doesn't matter.
Okay.
To me, in other words, because I have to assess a fine from the date that the repeat was discovered.
Yes.
And I have to assess a fine from today's date going
Okay.
forward. I can't grant extra time, that kind of thing. Does that make sense?
Yes, sir, and I'm not asking for time.
Yeah, yeah,
No, I'm
yeah.
asking, relevancy to the fine. And I just wanted to show Mr. Allen that I did get somebody there. It just wasn't in time.
Okay, do you want to introduce something
Yes,
into
sir, please.
evidence?
Yes,
All
sir,
right, then
please.
please show it to Mr. Jonathan and. Can you represent what these are photos of?
The front.
The
Front
front.
yard has been, yeah.
Okay.
There is still, obviously, that's the vegetation.
Mr. Jonathan, do you have any reason to believe that the photos are inaccurate for any reason?
No, I was out there yesterday and it did not look like this.
Okay.
It must have happened after I was out there.
Okay.
But
When were these photos taken?
They were taking it at the end of the day. And
Yesterday?
Yes, sir. And the fellow's name is Michael. He had hoped to be there when you were there. He may not have seen you. He appears to be somebody who works at night, so I presume that he got there by noon.
Is this, I'll admit this as Exhibit C, because your exhibits are going to be stipulated too.
Sure. And that just represents the front.
I understand.
The back is.
No, I get it.
extremely-
Yes, no,
Okay,
I marked
so
it on there what we're working on.
Is there anyone from the public who wants to be heard on these cases? I do see someone, yeah.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, thank you.
Please state your name.
My name is Donna Spangler. I'm adjacent to the property that is, got the code compliance.
I'd love to hear what you have to say.
It's been going on for 5 years at least, off and on. Paul was the original code compliance person that I had dealt with, and a privacy fence was put up probably half of the length of the adjoining property, which Paige had put in. And it does help with not seeing the mess, but it does not help with the odor. When we had these last few really, really hot days, it permeates. It's, as soon as I get humidity or anything, it's a horrible smell. It's like dead animal. I don't know what it is. I honestly don't. It's terrible. I have a son who has special needs. He has cerebral palsy and he has what's called bronchopulmonary dysplasia, which is like COPD in an adult, but he is a child that is 26 that has special needs and is permanently disabled, and has had multiple problems with not being able to be on my porch, which is a screened-in porch, because of that odor. He has asthma attacks. I have asthma attacks. If it's really bad out and humid that day, the odor is horrendous. I don't know what it is. I can't see it. I do appreciate code compliance. They are very diligent and has been out weekly. And he's very nice to deal with. I'm just trying to see what can be done. If there's nothing that we can do here, what can we do? I want to be able to enjoy my property that I've owned for almost 20 years, and I love it here. Citrus County is wonderful. We love it here. We always pay our taxes. We pay our property insurance and everything, and we love where we're at, and I'm not leaving. And now I get to stay here because I'm able to, through my work environment. I work remote and do billing. I work in healthcare. I've worked there for 40 years. And healthcare is very important to me. And my health is very important to me. So I want to know how this can be resolved, because I just want to be able to enjoy my property and have family over and be outside and enjoy my place.
All right, thank you, ma'am.
Thank you.
Is there anyone else from the public who wants to be heard on this case? Okay, I see someone else. And Mr. Jonathan, can you show your photos to Ms. Martin? Because I guess I need to take a look at them.
I sure can. Just the photos?
Yeah.
Okay.
I just want to understand.
Sure.
Mm-hmm.
All right, now, sir, can you raise your right hand
Yeah,
and be sworn in?
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Kent Fillmore.
Thank you, sir.
I just want to take a look at the photos myself.
Sure.
Yeah.
Yeah, those are, sure. No, I'm not disputing any of that.
And so what I'm going to be looking at is I'm kind of looking at it whether there's a health, safety, sanitary concern. It sounds like there could be.
I believe the smell is coming from, I have things that are in trash cans.
Okay.
And I believe a couple have been intrusion.
Okay.
And so I know from experience that, paper will have a pretty foul smell.
Paper?
Yeah, paper, once it gets wet, if the trash cans, if it's been sitting there, and I haven't been up there for a little bit,
Okay.
because I've moved in to take care of my mother.
Okay.
I'm not gonna dispute anything,
Okay. Well, sir, I'd like to invite you to make your public comment then.
I'd like to echo what Donna was talking about. We've owned the property next door to her since 2013.
Yeah, I'm more
And,
concerned about the back and the side, really.
When we initially moved, we come down here in the winter. And we
Sir, I'm sorry, I thought this would be faster. It's
Well, that's
not
what I
your
was
fault.
trying
it's gonna be
ask
quicker.
if it was supposed to be fast, because I knew it wasn't.
Okay.
I apologize, I tried to ask.
Okay.
I'll be happy to sit
Because I
down.
want to be able to focus on what
Yeah.
you're saying, so are y'all, all right,
I-
I'll just take a look if you don't mind. All right, now please proceed. Yeah.
Okay, thank you. Yes, when, we've owned the property since 2013, and when we first came down here, her uncle was inhabiting the house, and it was a beautiful property, and it's gone steadily downhill since she's taken responsibility for it. So I appreciate the opportunity to thank Code Compliance to do something about this. That's all.
Thank you, sir. So some of these photos are, I think are some of these of the backyard?
Yes, sir.
Okay. And how did you take the photos?
From the neighbors.
Okay.
I was given access
Yeah,
from the
it's
neighbor's
what I would
property.
assume.
You can see in the back, the vines are pushing the fence over. It's just really overgrown back there.
There's a lot of litter receptacles and
There
kind
are.
of garbage.
This-
And the majority of them don't have
It's an
lids.
artifact, I apologize.
Go ahead.
Mr. Allen.
Go ahead.
It's an artifact of just the setting, with my mother having her things there.
Okay.
So I do not contest that there's not an issue.
And I apologize for the foliage in the way, but it's the best I can do.
I get it, I get it. Is there anyone else from the public who wants to be heard on this case?
The only other, I do have one other thing.
Well, ma'am, honestly, each person only gets one comment. I don't mean to cut you off, but I'm gonna stick to the rules today.
It was the fence, that was all.
And so what I think, do you have any response to the comments? Because I think I'm ready to issue rulings.
My only responses to the comments are that, no, sir, I don't guess I do. It has been I had been told originally that things didn't bother them on both sides. I haven't been there in a while. It was already bad. I'm not gonna say it wasn't. I had a note from my medical provider that was going to just at least say that I have particular disabilities on my own, and I forgot to print it, but, so I'm just trying to come into compliance. I would have gone up, I just didn't have the opportunity to get up there when Mr. Allen first told me about it. That's the only reason we're here today, is I didn't have a chance to get to it.
All right. What I'm going to do on the overgrown case, 24-2043, is I'm going to assess a repeat violation fine of, on this one, I'll do it $50 a day, $200 a day going forward. On the junk case, I am going to maintain the county's position on that as a repeat violation, because that's more serious,
Yes, sir.
and it is affecting the neighbors. So it'll be $100 a day for 27 days. And then, in other words, that's the repeat part, and then it'll be $200 a day going forward. And that's the limit of what I can do, is I
understand.
basically assess fines. There's very limited circumstances where maybe I have a little bit more authority, but it doesn't look like in that case. So, all right, good luck.
Thank you.
Next case, Ashley Heron, case number 2024-1884, Code Officer Alan Jonason, page 12 of your agenda.
Good morning. Ms. Heron, are you Ms. Heron?
Yes.
Okay, I'll swear you in. Go ahead.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay.
Are you conceding that there is a violation on the property?
There is.
Okay, how much
And-
time do you need to fix it?
I filed for an unlawful detainer, so that has been filed with the court, so I'm waiting for them to respond.
So there's someone on the property?
Yes.
Okay.
Lots of someone's.
All right.
My understanding.
Have you
so-
ever done an unlawful detainer action before?
I actually, I haven't, but, so I hired legal assistance in that.
Oh, good.
So
Who'd you
it's-
hire?
I'm sorry?
Who did you hire?
His name is Lou, so.
Okay, Lou. All right, no,
Kind of threw me off there.
that's
I was
good.
sorry. Lou.
No, that's
Yeah.
fine. All right.
But yeah, I have the copy of that too, if you guys would like that.
Well, I mean, I'm familiar with unlawful detainer actions. I mean, they can be done quickly.
Hope so.
What's the county's recommendation on this?
$100 plus administrative costs.
Assuming that the unlawful detainer was resolved in, let's say, 25 days, 20 to 25 days, how much time do you think it would take after that to fix it?
Hopefully not long.
Yeah.
You know, I totally agree with you guys. You know, I like my place. I, take pride in what you have and take care of it. So I totally agree. And, I have family that'll help me clean it up as well once we, are able to get them gone off the property, so.
Is there anyone from the public who wants to be heard on this case? All right, then I'm gonna grant you 60 days from today to abate the violation, and it'll be $100 a day if it's not brought into compliance in 2 months.
Thank you, I
All right,
appreciate it.
Thank you.
Thanks.
Next case, David S. and Janice L. Jorstad, case number 2024-2104. Code Officer Cody McGuire, page 14 of your agenda.
Well, you got up there quick.
She wants to get out of here.
We don't have to wait
Yeah,
for him.
I got
just
another
wait a minute.
appointment.
Yeah.
Ma'am, can you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am.
Okay, and what's your name, ma'am?
Janice Jorstad?
Okay. Ms. Jorstad, are you conceding that there's a violation on the property?
There was. I hopefully that this will clear it up today.
Okay, were you there yesterday
I was
or
there.
Monday?
I'm sorry. I was there on the 17th.
Okay, and was there a violation at that time?
There was then, and we have since talked.
Okay, would 7 days be enough to abate the violation?
We
If there's
took
one-
care of it last night.
Okay.
Here's a picture for the record.
Okay, so this is a new, look, either I find that there's a violation and you get a time to comply, or you dismiss the case. It's one or the other. Are you dismissing the case? Do you know if there's a violation there?
Well, based off that picture, but I would have to get my own.
Okay, so, I mean, the county said that when they went out there 2 days ago, there was a violation. You're saying it was, I guess, fixed in
Last night, we took care of it.
Fixed last night.
And I got the picture this morning at Walgreens.
So I think they need an opportunity to re-inspect. I'm gonna find that there's a violation, grant 7 days to bring it into compliance.
Okay.
What's the county's recommendation?
$100.
Okay, it sounds like, worst case scenario, you're very, very, very close, and 7 days would be more than enough time to bring it into compliance, correct?
I mean, as far as, we have done what we were told to do, so.
Okay. All right, then, in an abundance of caution, I'm worried, because sometimes there's a miscommunication, and it's not always clear. So I'm gonna grant 14 days to bring the property into compliance. If it's not brought into compliance, $100 a day fine. Okay? Thank you, ma'am.
Thank
Good
you.
luck.
Thank you.
Oh, I'm sorry, is there anyone from the public who wants to be heard on this? Nope. Goodbye.
Next case, Clear Card Holder LLC, case number 2024-2134. Code Officer Julie Wilkinson.
Oh, it's not gonna be a quick one. All right,
Okay.
so,
All right.
no problem.
She don't know which case she's here for. Next case, Audrey McSherry and Vernon J. Smith, case number 2025-008. Code Officer Cody McGuire, page 19 of your agenda. Expert on the case, Joanna Katu, Land Development Director.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name.
Lena Stickle?
Can you spell that, please?
Yes, it's S as Sam, T as Tom, I-C-K-E-L.
Thank you.
Ms. Tickle, are you an owner of the property?
I'm actually going through the company. It was handed to me basically through a friend. So I'm going through lease to own.
Oh, a lease to own.
Yes.
So do you occupy the property?
Actually, I was working on getting permits and stuff like that for it, but I had an invasion. So I'm getting violated for having a shed there that they already put. And I brought the trailer to basically get it out of the flat zone where my dad's house is, and I put it there. So I guess that was against the violation.
Okay, I'm just trying to understand, I mean, are you in possession of the property? Do you?
I am in possession of the property.
Okay, that's what
right
I
now.
mean,
Yeah,
okay.
sorry.
And you're
Language barrier.
conceding that there is a violation just based on what, the shed
The
being
shed,
there?
yes.
Okay.
I already talked to Cody in regards to. 'Cause
You
I had-
understand?
Yeah, because I wasn't there when he was trying to get hold of me, because I had an
Ah,
invasion.
yeah.
And then I had a concussion because of it.
Yeah, yikes.
So I was gone for a month. So when he got hold of me, I actually didn't fight it. I understand. I just need some time.
Well, you can fight it if you want. I'm
Well,
not
no,
trying
I just
to-
need some
okay.
time because the shed is not under my name.
Okay.
So
How
I'm
much time
trying
do you
to get-
need?
I need at least 2 months, 3 months to get hold of
To
the
move a
person.
shed?
Well, it's not under my name, and I guess it's the company, whatever Sheds Galore right there in Crystal River. It's from their company, but I'm trying to get the guy who was under his name to have it removed, because I can't just go up to them and say, hey, can you remove the shed, that you guys leasing to somebody?
I mean, who are Vernon Smith and Audrey McSherry?
They passed away, so the leasing company that I'm part of, they're the ones who take over their lease. Basically, it's like you make payments every month, and then after so many payments.
I'm familiar with the structure, but I
Yeah.
guess did an estate deal with it? or
Yeah, it's
pro-
like a estate deal, basically. Well, it's through a company called Discount Lots, and you could look them up. They're online.
Yeah, I mean, I don't know.
I have the contract to.
I don't think they necessarily determine who the owners, of property are and everything like that. So I guess what I'm trying to get at is, well, let me ask this. Is there anyone from the public who wants to be heard on this case? Mr. McGuire, have you had contact with any owners or representatives of the property except for Ms. Stickle?
So the only contact that I've had was with a gentleman named Jack, who stated that Audrey McSherry was the deceased grandmother, and then Jay Smith Vernon was the deceased father.
Okay.
They're a state company.
Okay, so I actually looked into this after Mr. McGuire spoke to me. There is a deed that was not recorded. So there's something wrong with it. Back from 2021, where a Vernon J. Smith Jr. sold the property to a WPRE Ventures 1 LLC, but it was not recorded. So for our purposes and the PA, the apparently deceased parents are still the legal owners of the property. So I'm not sure who her rent-to-own is with.
Well, property descends at death regardless of what happens in a probate. So I don't know what they were intending. Is it vacant land?
Yeah.
Yes, sir.
Yeah. So it wasn't a homestead. The deed,
I do have a contract that I signed with the company, and I've been making payments on it. So
Well-
I could forward that to Cody so he could have it on file.
I guess the only thing is, I don't know that you have standing to oppose it, if that makes sense. But you as a party can certainly make your views known, and you have saying that 2 to 3 months is what you need. How big is the property?
0.25.
It's a quarter
acreage.
acre?
A quarter acreage, yeah.
All right, well, what's the county's recommendation?
That would also be $100 a day.
I'm gonna give you 2 months. I'm gonna give you 2 months to
Thank you.
get rid of it, and if it's not brought into compliance as ordered, $100 a day. Okay?
Thank you so much.
All right, good luck.
Thanks.
Thank you.
Are there any others that are, no, everything else is,
Rest of them,
okay.
they are
Then however you wanna do it then.
Let's get her. William Patrick McEwen, case number 2024-2159, Code Officer Alan Jonason, page 18 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-02159, special requirements for all accessory structures. A violation of Citrus County Land Development Code 3102. Address of the violation is 3211 East Buffalo Lane, Hernando, Florida. Property owner is McEwen William Patrick. This property is .08 acres and is zoned MDR MH and was purchased on 2 April 2018. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 17 December 2024, photos from a compliance inspection on 30 December 2024, and photos from my final inspection conducted on 18 February 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, a copy of the posting affidavit, and a copy of the PA.
All right, is there anyone from the public who's going to want to be heard on this case? Nope. All right, exhibits A and B are admitted as evidence.
On 17 December 2024, I conducted my initial inspection and observed the property to be in violation with numerous vehicles and other items on the property. On 17/2024, a notice of violation was issued for special requirements for accessory structures, which is a violation of the ordinance mentioned, or of special requirements for all accessory structures. On 30 December 2024, I conducted a compliance inspection and observed the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 18 February 2025, the property remains in violation. Expert witness, Land Development Director Joanna Coutu. If you need it.
Extremely small, .08 acres, medium-density residential with mobile homes allowed, should be vacant. Nothing new.
Yeah. What was the county's recommendation?
$150 per day.
I'll grant 30 days and $150 a day if it's not brought into compliance.
Thank you.
Thank you.
Next case, Joseph R. Kuchik Jr., case number 2024-590, Code Officer Cody McGuire, page 15 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Please proceed.
All right, Cody McGuire, Citrus County Code Compliance Officer, case number 202400590, use standards 2412 General Commercial District, GNC. Address is 3388 West Denellen Road, Denellen, Florida. Property is 0.54 acres and is on GNC. Property owner is Joseph R. Kusel Jr. Good service via signed certified mail return receipt and posting at the Canto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during an initial inspection on March 27th, 2024. Photos taken during a corrective action inspection on December 27th, 2024. And photos of my final inspection on February 17th, 2025.
A 9-month gap?
Yes.
Why was there a 9-month gap?
Kind of slipped through the cracks.
Okay.
And then Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
Okay. Is there anyone from the public who wants to be heard on this case? I don't see anyone. Exhibits A and B are admitted as evidence. So it's being used as storage, essentially?
Yes, sir.
And it's supposed to be vacant?
Yes, sir.
What's the county's recommendation?
$200 a day.
Normally I wouldn't jump in. Storage is not an allowable use in general commercial. You need a master plan, a PUD by the commissioners. It's an extra level.
Wow,
So it's
yeah,
not-
okay.
Not just pulling a permit in this case.
That makes sense. All right. It's a lot, but they've had it going on a long time, so I'll grant 30 days and $200 a day.
Thank you.
Thanks.
Next case, David Fiera, case number 2024 2081, Code Officer Julie Wilkinson, page 7 of your agenda.
All right, welcome back, Mr. Ferrera. Sorry about before, I just want to make sure I get everyone out if it's easy,
I understand.
if that makes sense. But yeah, so let's just treat this like a regular hearing then and go through it. I think we probably can't be that far off, but I'll let you proceed with your case, Ms. Wilkinson.
Yes, sir. Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2402081, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 1 Beverly Hills Boulevard in Beverly Hills, Florida. The property owner is David Ferrera. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on December 12th, 2024. Photos from a corrective action inspection on December 31st, 2024. And photos from my final inspection conducted on February 17th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Okay, sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this case. I just want to go through the steps. I think I know what your case is. In other words, I think your case is that we're pretty much there already, but we'll get into that.
No, that's what it looked like.
Okay.
And I'll go into why it looked
Yeah,
like that.
that's fine. And I think, did I ask, is there anyone from the public who's going to want to be heard on this case? Is it just, okay, I don't see anyone. Sometimes silence is the better part of valor, you never know. Okay, I don't see any other response. Exhibits A and B are admitted as evidence, and let me just refresh my recollection. I mean, I remember the property, actually, so let me just take a look here. Okay, please proceed.
This property is a community shopping center, 0.47 acres, and is zoned general commercial. On December 12th, 2024, an initial inspection was conducted. Loose trash, discarded clothing, discarded furniture, miscellaneous junk and debris were observed on the property outside, exposed to the elements, and not on display for sale. On December 12th, 2024, a notice of violation was issued for accumulation of junk and debris. On December 31st, 2024, a corrective action inspection was conducted and the property remained in violation. On January 8th, 2025, the Director of Code Compliance and I met with Mr. Ferrera on site and walked the property and advised him of the violations. As of the final inspection on February 17th, 2025, the property remained in violation.
Okay, so Mr. Ferrera, you can cross-examine the witness, or you can just present me your case if you want.
I'm just going to present what I
Okay,
have.
all right.
Okay, since the hurricanes, people have seemed to think that they can just drop even flood-damaged furniture in the parking lot as a donation. They had an extreme problem with that. The pastor and manager of this thrift store has blood cancer. He's been very sick. He hasn't been monitoring. I've been out of state an awful lot. I had a wedding. I've been gone probably 2 months of the fall. My father was living with me the rest of the time because his assisted living flooded, and I haven't been over there very much. And it did get in pretty bad repair. Once I was away, and I did not get the original notice until, I believe, the 22nd or 23rd of December, which was almost 2 weeks after it was sent. In fact, post office said it was about to be sent back when I finally got my mail and read it. We've been attempting to get everything cleaned up. I probably made 20 trips to the dump myself, trying to help them get things in order.
I can definitely see improvement.
Yeah, I do have pictures here. If I can put those into evidence to compare them against.
And Ms. Wilkinson, you've already reviewed them correctly. Do you have any objection to them being?
Absolutely not.
All right. And you'll represent that these photos were taken when?
These were taken yesterday.
Okay, yesterday. And I believe the photos I have, the most recent ones here were taken Monday?
Yes.
Yeah. On President's Day?
Yeah.
Y'all were hustling on
Okay,
President's
now
Day?
on Monday, I will tell you, they got 2 trailer loads from a house clean out.
Yeah.
They were in the side parking lot, as thrift stores do, sorting, putting trash in the trailer, and the rest of it going into the garage stalls.
So let me talk to Ms. Wilkinson about these photos. So, just so I'm on the same page, when this store has like goods, I guess for sale, like the piano, the table, the chairs, the lamps that I'm seeing on page 2 of this, I'll call Exhibit C, is that okay?
Yes, because they're approved for outdoor sales, so
Good,
they can have it
okay.
on display.
So I'm on the same page with you there. And then there's a photo of the garage, the warehouse, so to
Yes.
speak. Is there anything that is a violation
No,
there? All right,
no.
okay.
But that's for a different case. That's not for this case, that property.
Got it, okay. And is the trailer also a part of that other case?
Yes.
Okay, so I'm gonna skip that for now. What about the church house?
The other case.
Other
That's-
case, all right. So the only thing, now I'm gonna show you page 1.
The other case.
This is also the other case?
Yes.
Oh, okay, all right. So, the only question is, what remains from your perspective as a junkyard condition on this general commercial property?
So in that photo, nothing remains. However, there is a small portion of the property that you can't see in those photos that he submitted, that I'm just unsure if there's still something there or
Are they in
not.
your photos?
Yeah, they're in my
Okay.
photos.
So tell me, and if you can, yeah, I'll give you your Exhibit A. Where is the part that he hasn't provided counter evidence?
Can I come forward and?
Yeah.
This specific area, right? Whoops,
We're looking at page 1.
Where these trailers
This will make
are.
great YouTube TV.
So you have a photo showing this area.
And
yeah,
this
but
area.
not-
I
oh.
have a front area of that. There was nothing there.
I didn't notice
Okay,
that.
and,
Right here,
and,
right? Is that this?
yeah,
That's
and
this?
as for the trailer, that is their trailer that they put the furniture
see.
in that comes in that can't be sold. And that goes to the dump roughly every 2 days.
Okay. I can
And
see
I know,
that.
I know, we can't have a trailer without a plate. That has a plate, that is regularly moved.
Well, that's
Matter
not
of
the
fact-
case here. I mean,
Yeah.
it's not
Well, that
a
is something that's
lack
been a
of a
regular
tag.
complaint of
Okay.
ours, is that we have a trailer that we use for trash.
Okay, all right.
And that is why I want to get this resolved today,
Okay, that's
because
So, do you think it's been brought into compliance
Well,
from what you can see?
From what I can see, I can't say for sure because there is something in the trailer. I just can't tell what it is, so I'd like to see it in person.
something in what.
In other words, that
in
it
what
could
trailer?
be like uncovered. Why don't we go back to the podiums, if you would? Right, I think I understand what you're saying.
Are
There
we
could be
not
something
allowed-
subject, hold on. There could be something subject to the code that's loose, unsecured, or uncovered on the trailer that qualifies as junk
Yeah.
under the ordinance.
Yes.
The trailer is covered every single night. They
Mhm.
have a giant tarp that gets strapped over the top of that every single night. That picture was taken at 3 o'clock in the afternoon. They just returned from the dump. The trailer was totally empty at that point.
Well, it is not completely empty. I mean, I'm looking at a picture that you took, and it's not completely empty.
Yeah. Well, like I
So-
said, that is their trash trailer, and it's covered every night. They are actively.
I know, I'm based on the
Yeah.
evidence you
Yeah.
gave.
Can I-
All right, yeah. So, that said, if that's the only thing that is an issue,
I'm not seeing anything in the trailer. Can you point where you see something in the trailer?
no, I'm satisfied that it's obvious that there's something in that trailer.
In this gray trailer.
That's not what, Ms. Wilkinson, you didn't point to that. I want him to understand.
What trailer is she talking about? That's what I'm. Okay, that trailer right there had just arrived with merchandise from
Mhm.
someone's house. They're
Mhm.
sorting that. The first unit of the stores
Yeah.
is where they keep the merchandise.
If you would, please go back to the microphone so your comments are on the record.
They need to be able to process merchandise
They
coming
are,
in.
and I
Any
mean, that's
thrift
not a
store-
code violation, correct?
No, so processing the merchandise is fine, you can do that, but when it's set out and discarded and nobody's doing with it, no active sorting is happening.
There's a time limit to that kind of thing.
The trailer is never sitting more than 24 hours.
Okay.
And it gets covered at night.
All right, so what I'm gonna do, is there anyone else who wants to be heard on this? Look, I mean, I'm satisfied that if it isn't totally compliant, it's very, very close. If you wanna see that there is well, actually, let me think about this for a second.
Could I add something to this,
Yeah.
please? So covering the trailer with a tarp at night does not satisfy as abating a violation. The junk needs to be inside a walled-in roof structure
I can't understand
or
how
in a receptacle with a lid, not a
how
tarp.
you can't have a trailer on your property with stuff that's going to the dump that's not left from, I was told at the previous hearing that it can't be sitting in place for more than 48 hours and it has to be registered. These trailers are never sitting in the place for an entire business day. They move from one side to the other, from the garage to the house. This isn't something that could be put into a walled area and then taken to the dump. This place spends hundreds of dollars every week taking people's trash that they think are donations to the dump. Forcing us to get some kind of a wall dumpster would be a financial burden beyond
Yeah.
what this
I'm
charity
looking-
could handle.
I'm looking for the 48-hour, I know we've encountered it,
20-31A.
20-31A, okay. Right. Right. Junk which will not fit into standard size litter receptacles and which is set out for no more than 48 hours for pickup and removal by a trash hauler. So that's stuff that is going out usually onto the front yard and it's waiting for trash pickup and it can be there for 2 days but no longer. Here, what Ms. Wilkinson is talking about is, look, you can't have junk unless it's stored in enclosed litter receptacles or completely enclosed buildings. Stuff that won't fit into standard size litter receptacles, which are set out for no more than 48 hours for pickup and removal. Recyclable materials stored in receptacles. Junk stored in a lawfully established and maintained junkyard, et cetera, et cetera. So it is the case that you can't just throw a blanket or a tarp on something and call it enclosed under the ordinance. But that said, if it's something that's moving.
Constantly.
Yeah. So, Ms. Wilkinson, do you have any information that what he's representing about this trailer would be inaccurate? That it's stuff that's being offloaded, essentially?
No, I don't have anything that would contradict that.
Okay.
We've hired a person that does nothing but keep that place in compliance now.
Yeah, so here's what I'm gonna do. Based on the evidence, I'm not going to find that there's a violation today. I am going to find that there was a violation. In other words, between
I
December.
totally agree there was a violation.
Okay, so I'm gonna make a finding that there was a violation in this case, but that as of today, it no longer exists.
Thank you.
Okay? All right,
So admin costs?
admin cost.
Thank you.
And is that for, he has 2 cases, which one was it?
That's right.
This was
One is
8-1.
2181.
Okay, thank you.
Next case.
Next case, David Fiera and Betsy Cruzen, case number 2024-2082, Code Officer Julie Wilkinson, page 8 of your agenda.
Now, Mr. Ferreira, are these photos also going to be your evidence for
Yes.
this hearing? All right.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And your name, ma'am?
Betsy Cruzen.
Okay, thank you very much.
Yes, I would just like to say, based on the photos he took, as long, if they're accurate, I would like to dismiss the case.
Okay, do you have any opposition to this second case being dismissed?
No, none.
Case dismissed?
Thank you.
Thank you.
Thanks.
Next case, Clear Card Holder LLC, case number 2024-2134, Code Officer Julie Wilkinson, page 5 of your agenda.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Your name, please?
Ian Jobert.
Thank you.
Welcome back, sir.
Thank you.
I travel a lot. I have
Yeah, if y'all would,
Let me just give you this.
sorry, Miss Wilkinson's busy.
Before you repeat it, just call me, please. Thank you.
All right.
Okay. I am ready?
Yeah.
Okay. Julie Wilkinson, Citrus County Code Compliance Officer. This is a repeat violation initially observed on January 8th, 2025. The address of the violation is 360 South Saginaw Road in Lecanto, Florida, 34461.
I object to the repeat violation.
All right, we'll get into it.
Case number is 2024-02134, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owner is Clear Card Holder LLC, has been previously found guilty of the same violation at 4535 North Remington Terrace in Hernando,
I
Florida.
object to the relevance of that
All right.
separate case.
We'll get into it.
34442. On August 19th, 2022, case number 2164933 with $366.28 in imposed fines. That case was abated on January 4th, 2023. I have good service via posting on the property and posting at the Lecanto Government Building and signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, the findings of fact, the order imposing fine, and order acknowledging compliance from previous case number 2164933. Exhibit B, photos taken during an initial inspection on January 8th, 2025. Photos I took during my subsequent inspections on January 16th, 22nd, 28th, February 4th, the 11th, and a final inspection on February 17th, 2025. Exhibit C, a copy of the repeat notice of violation and hearing, a photo of the notice of violation and hearing posted on the property, and a copy of the general pre-hearing order, and a copy of the posting affidavit.
Now, first of all, I think in order to anticipate your point about the repeat violation, I'm going to read you the definition of repeat violation in the code. This is section 19-24, and a repeat violation shall mean a violation of a provision of county codes by a person who has been previously found through a code enforcement board or any other quasi-judicial or judicial process to have violated or who has admitted violating the same provision within 5 years prior to the violation, notwithstanding that the violations occur at different locations. So is this the same code section, just on a different property?
Yes, sir.
That's their basis?
Yes.
All right. So I'd like you to show Mr. Javert a copy of these proposed exhibits. And sir, take your time and let me know if you have objections to them being evidence.
It's very small. I couldn't figure out how to make it bigger.
Just assume Remington's not relevant, just to make it a second violation. I don't need to object to the document on Remington. No objection to the document.
Got it, yeah. That was the case where I think you made a defense about the laser measurements, or was that?
Yeah, we had a hearing and a continuance to determine the actual property lines.
That was interesting. No, that's why I remember it. It was interesting.
Just as an aside, had to build a road down into a mining pit to get the garbage out. It took a while.
It did look steep.
Okay, these are accurate representations of the property in the pictures.
That you said inaccurate?
Accurate.
Accurate,
Yes.
okay.
Yes. This is all, no objection to it being entered as evidence.
Okay. Is there anyone from the public who wants to be heard on this case? And I don't think anyone is left from the public, so I don't see anyone there. We'll go ahead and admit exhibits A through C without objection. I want to look at them before we get into anything.
If we could have a moment to put things back in order.
I mean, I don't know if well, yeah, having them in order is a good idea. Okay, now I'll just take a quick look real quick. I don't need to see Exhibit A. Is the carport on the property?
Nope.
Okay.
No, sir.
Okay. Is there still a violation as of the 17th?
No, it's abated
It did abate. When did it abate?
on the 17th.
Okay. Is the property being rented or is it?
It is currently vacant. It was being rented.
Gotcha. Okay. All right. And you're contesting a violation? You can. I'm not.
Yeah, I am contesting the action, yes, that's being brought against me.
All right. Then Ms. Wilkinson, please proceed.
Yes, sir. This property is a single family residence. It's 0.09 acres and zoned medium density residential. I conducted my initial inspection on January 8th, 2025, and observed a large overflowing pile of trash, furniture, bedding, clothing, miscellaneous junk and debris on the property. On January 10th, 2025, I posted the repeat notice of violation and notice of hearing at the property. I've spoken to the property owners who called and asked about the notice that was left at their property. The property owners stated that they had evicted the tenant and found the notice when they went over to clean out the property. I advised them of the violation and that it was a repeat. I conducted follow-up inspections on January 16th, and the property remained in violation. On January 22nd, 2025, I conducted another inspection and found that all the trash and furniture and junk had been removed. There was also workers there actively working on the property, so the construction debris, tools, and fresh pile of tree debris on the property were not in violation at that time. On January 28, 2025, I conducted an inspection and found that more furniture was being stored outside, as well as the construction material with no active work being done, and the same pile of tree debris had not been picked up. The property became in violation once again. Additional inspections were conducted on February 4th and 11th, where the property continued to stay in violation. A final inspection was conducted on February 17th, 2025. The tree debris had been removed and the property was in compliance.
So when you first inspected the property, was the tree debris there?
No.
No. So that was a part, as far as you know, and I'll definitely want to hear from you, but from your perspective, that was something that was done after a tenant was evicted and they're cleaning up the property and that kind of stuff?
Yes.
How long do they have to keep the vegetative matter there before it becomes a violation? If that makes sense.
Yeah. As long as you're actively working on clearing the tree debris.
Okay. I have to walk through this with you. So when there's a pile that is cut down one day and it might take, a day to move it, but they leave the property, or maybe they go to a different property on day 2 and they come back day 3.
Mm-hmm.
Is it a violation on day 2 because they've left it? Does that make sense? Because they're not actively working on it?
Yeah.
They're coming back day 3?
I understand. I may be wrong, but I'm going to say yes, that
just
would
wanna know.
be a
Okay.
violation.
I think that we've had these discussions over the years, and the
Mhm.
code has been well defended by both Ms. Harrison and Ms. Antrim. I remember Ms. Antrim in particular defending even like, you know, a sapling growing out of the ground, you know,
Yes.
being a violation of the code. And it's a concern for me. I think you've got a case here where you want the property owner to maintain the property. You want the property owner to keep things in good shape. And I know all y'all care about is compliance. I don't know if I'm anticipating his comments. These are the things that are coming through my mind as I look at
understand.
it. And when was your first contact with the owner?
Give me one
The
second.
22nd, I think you said, or?
No, that was when I conducted,
I mean, I see what you did. You didn't violate for the actions of the tenant. You know,
yeah.
I get that.
Around, you know what, you were around the 22nd, January
Okay.
22nd is when I had contact.
All right, well, let me just turn to you, sir. I mean, what would you like to say?
We had a tenant in there. We don't have the ability to go onto our own property and remove tenants' items. We need to legally obtain possession of the property again before we do that. We had started the eviction process and the tenant had ended up leaving. They not only were not paying us, they didn't pay their power bill, had no electric, no water, and ended up moving out.
They abandoned the property.
Yes.
Yeah.
We got in there and cleaned everything up very quickly as soon as they had left. I would like to address the posting. Our tenants obviously were avoiding us and certainly did not make any effort to notify us that there was any posting of potential code violations on the property. Indicated in that paperwork, mail was sent out on January 10th, and the mail goes through the corporate headquarters in Las Vegas. Our postal service will probably take 5 days to get a letter there, and once it's there, the corporate office needs to open it, go through it, scan it up, and email it to the.
This is a Nevada LLC?
Yes, I believe so. Yeah. Or Wyoming, one of the two.
Well, both hide owners' names, so it doesn't really matter. Both hide owner names if you want them hidden, so it doesn't really matter.
We found out about this through taking possession of the property and finding the notices in the garbage before we found out about it from the mailing that was sent to us. We started the cleanup immediately on the property once we had possession, immediately within 1 or 2 days. Got most of the debris off, yes, went in there and did some cleanup and some stuff on the inside of the property that created a little more debris, and it was all moved off within 1 or 2 days of creating the debris. The brush pile there were some trees growing up right next to the house, or saplings, pulled them out, made a pile, and the furniture falls in the same category. The dump doesn't allow you to dump the brush with the garbage, and the furniture can be brought separately, so things were put in separate piles and taken to the dump separately. So on any given day when she went by, there could have been a couch out there and a chair that didn't go to the dump with the garbage because we can bring it separately and not have to pay extra money for it. My main objection is to the actual notification to us as the owners. between the notification and the times of these fines starting, I feel is insufficient for us to take care of the problem. I believe I have demonstrated that we're more than willing to take care of these problems and do so in a timely manner once we're aware of the problem. And I believe that we have taken care of it. I believe you said it's abated at this point. So my objection is to the time frame of the noticing and the fines.
And I get that. I mean, we have dealt, for whatever it's worth, you are not the only one in this position where you're a landlord and your tenants screw you over in some way, shape, or form. And but you as an owner under the code are responsible for the property. Tenants can also be held responsible, incidentally. But it's hard because, you know, if you've got notice and your tenant is doing something, it's hard if you don't have possession once you have a repeat violation, because the repeat starts from the date of the violation going forward. So I've struggled with these cases, but I've never had a case where it's been a repeat violation and it's a level 1. It's a level 1
Yeah.
on our scale
Yeah.
of 1 to 10.
Mhm.
And the owner, I think unarguably, went to bat, got it cleaned up,
Yeah.
looks a lot better.
Mhm.
So I'm a big believer myself in what's called textualism and following the law as it's written. And I think undeniably there was a violation. I think the notice was satisfied, but I'm not going to assess a major fine on this. What is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests the special master assess a fine of $50 per day, along with the administrative costs to begin on the date of the posting of the property, which was January 10th, 2025, and continue until January 21st, then begin again on January 28th and continue until February 17th. That would be 33 days at $50 a day, totaling $1,650.
Can you give me the timeline again? Why is it 33 days?
Well, yes, January 10th to January 21st.
Oh, I thought you started it at January 28th.
And then from January 28th to February 17th.
Oh, can you walk this through me again? I'm sorry.
Yes, sir.
I'm not understanding.
Okay, so from January 10th to January 21st. The 22nd, when I went to inspect, there were workers there, and the stuff was cleaned up. So the construction material and debris, I said that property was in compliance at that time.
I see.
So then when I went back for another inspection on the 28th,
Okay.
it was back in violation until
Okay.
the 17th.
All right, I got it. Based on the circumstances, I'm going to assess a fine of $3 a day, which puts us right at about $100, plus administrative costs. And look, I mean, that's just based on the circumstances. And my only guidance to landlords is, this is the way the code reads. This is the way it applies. When there's a repeat violation, I don't know really what your remedies are with the tenants, except a security deposit that can protect against this kind of thing. I don't know, but that's what I'm gonna find. Okay?
Thank you.
That's it, thanks.
Next case.
Just, is this payable today, or did it take a
I'm
while
gonna
for
have to
paperwork?
issue the, yeah.
Thank you.
Yeah.
Thank you. Next case, Michael E. Neal, case number 2024-2188, Code Officer Julie Wilkinson, page 20 of your agenda.
I'm ready when you are.
Yes, sir. Julie Wilkinson, Citrus County Code Compliance Officer. Case number 2402188. Accumulation of junk and debris. A violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 9453 North Mendoza Way, Citrus Springs. The property owner is Michael E. Neal. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on December 27th, 2024. photos from a corrective action inspection on January 16th, 2024, and photos of my final inspection conducted on February 17th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right, without objection, what's been proposed as Exhibits A and B is evidence. I don't see anyone from the public. What's the county's recommendation?
It's going to be $50 a day along with the administrative costs.
I mean, I think the photos speak for themselves. You took the photos on the dates indicated.
Yes, sir.
Okay, any contact with the owner?
No, but they have made an effort to clean up, and it's just very minimal at this point.
It's just not that much either, though. So
Yeah.
I'm gonna give them 14 days, and if it's not brought into compliance as ordered, I guess, you said 50?
Yes, sir.
$50 a day.
Thank you.
Thanks.
Last case of the day, John Stasio, case number 2024-2198. Code Officer Julie Wilkinson, page 9 of your agenda.
Okay, Julie Wilkinson, Citrus County Co-Compliance Officer. Case number 2402198. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 10 South Jackson Street in Beverly Hills. The property owner is John Stasio. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on December 27th, 2024. Photos from a corrective action inspection on January 16th, 2025. And photos from my final inspection conducted on February 17th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a photo of the notice of hearing posted at the property and at the Lecanto Government Building, as well as a copy of the posting affidavit.
Okay. Without objection, what's been proposed as Exhibits A and B is evidence. Yep. All right, you took the photos on the dates indicated?
Yes, sir.
Some cool cats.
I know. They had the fattest heads. Oh, man. I wanted to touch them so bad, but I didn't want to trespass.
But it does look pretty bad. Yeah, it's, this is a solid 5.6. So what's the county's recommendation?
$100 a day.
Okay, 30 days, $100 a day.
Thank you.
Are there any other cases?
That's it.
No. Are there, I mean, this was kind of a test run for the, rush them up, do the, I think I might like to do that at the beginning of all our hearings.
That worked a lot better.
If we can pull it off. I don't want to put y'all in a bad position, but you might think of ways to make it run better than I did, this morning. I would just think about it because I think there's a lot of potential there. I don't want to, of course, no one needs to be coerced or their arms twisted to do that, but I think our hearings will run a lot faster, and maybe it gets them thinking about whether they're really going to contest it or not anyways, so.
So what you're saying is we have a long hearing to start, so everyone knows what it feels like to sit here for an hour and a half, and
Well,
then ask if anybody wants to
I
go
think
forward.
I should modify my pre-hearing order probably to talk about that as well. Think about whether you're contesting. Is there anything else y'all want to take up?
You're aware that we're going to be moving our hearing to the.
Starting in May, I heard?
Yes.
Yeah.
It'll be closer?
Yeah,
It'll be
heck, you're
closer.
right. Didn't
Right,
think
20
about that,
minutes.
yeah. Well, are you going to be in the old or the new?
The new
The new
courthouse.
one, yeah, okay,
Yes.
great, yeah, I like going there, so I look forward to it. Anything else?
No, sir.
Okay, then the time is 12:41, this hearing is adjourned.